Hey, Rob. Rob. Yes. Please rise. The Justice of the Appellate Division, Supreme Court, First Department. Yea, no person time to visit of the Appellate Division. Draw near, give the attendance, and you shall be heard.
Okay, please be seated. Everybody.
Be seated.
Okay, good afternoon and welcome to the Appellate Division First Department. It's the first time I've been sitting in the courtroom for 6 months, so I'm happy to be here. And I'm happy to see some of you here and the rest of the people that will be here this afternoon. I'm going to call the calendar and just tell you whether the case is submitted or if there's time given. And that's all I'm going to do for the calendar today, so nobody else has to respond. The first case is People versus Sean Hyde. That's submitted. Thomas versus NYC DOE. That's submitted. Case of S. Jalen, that case is submitted. Silvers versus City of New York. The appellant has 5 minutes and 2 for rebuttal, and the city respondent has 7 minutes. People versus Diane Moore is submitted. People versus Raimundo Sepulveda, that case is submitted. First Equity versus Harmony Group. The appellant has 6 minutes and the respondent has 6 minutes.
Your Honor, can the appellant have 1 minute in rebuttal?
Then I'll give you 5 and 1, okay? You're welcome. KH48 versus Muniak, the respondent has 5 minutes. Everett versus Timmons is submitted. People versus Aaron Johnson, the appellant has 6 minutes, the respondent has 6 minutes. G. Anay is submitted. Empire Center versus New York City Payroll, each side has 7 minutes to argue. Montgomery Realty versus NYC DHPD, the appellant has 6 minutes and 2 for rebuttal. The respondent has 6 minutes. McCormick versus NYU Langone. The appellant has 6 minutes and 2 in rebuttal. The respondent has 8 minutes. People versus Jose Tatis, that is submitted. Atkins versus Metronome Events. The appellant has 8 minutes and 2 in rebuttal. The respondent has 8 minutes. People versus Ruben Roland is submitted. Piet Turnell versus Smiley and Smiley. Each side, well, the appellant and the respondent each have 5 minutes. White versus City of New York. The plaintiff appellant has 5 minutes and 2 in rebuttal. The city has 5 minutes, and defendant project renewal, respondent project renewal has 5 minutes. Okay, so that's the time. We'll all try to do the best we can, not talk over each other. It's a little harder with masks, and we're going to all do the best we can today. So the first case on for oral argument is Silvers versus the City of New York. Just give me 1 second, Counselor. This is plugged in. Sorry, it wasn't plugged in. The officers help me out. That is not plugged in. Oh, here. Okay. Fine. Okay, Counselor, you may start your argument. Thank you.
Good afternoon. Brian Glass for former New York City Department of Education tenured teacher John Silvers. I realize I've been bringing these kind of cases in front of this court for more than 10 years. And this court has served as a useful check on the 3028 process in New York City on those outlier cases where it's questionable whether misconduct has been committed or the penalty is really quite shocking to the conscience of a justice. I realized one of my first cases was in fact in front of Justice Scarpella in a case called Beverly Riley, which was a 16-year teacher who was alleged to have committed one act of corporal punishment involving a student, and I believe Judge Scarpella found that to be shocking under the circumstances, and that penalty was vacated for a lesser penalty, and it was affirmed on appeal. Over the years, there have been other cases that have been vacated by this court or lower courts. One, in fact, was Jonathan Pole's, which the same justice below had affirmed after a termination, and this court reversed it and decided that it really wasn't misconduct under the circumstances when they looked at the facts and took a fresh look. A more recent case after Bolt, which has made the standard even harder, is a case called Dukovsky, where again the court found that under the circumstances it just did not appear that this was misconduct to them.
Counsel, I have a question. So how does the 2018 Court of Appeals case in the matter of Bolt change that landscape? Because all the cases I think you're referring to all predate the 2018 decision, which was pretty clear in terms of what they told us what we can and cannot do when it comes to shock the conscience, correct?
I believe
Unless
so.
I read it wrong.
There have been a few cases since then, like Dukovsky, I believe, is one of them, where the court has still shown some...
Which court?
I'm sorry?
Which court, when you say the court has still, which court is?
This court. I believe Dukovsky is out of this court, which found there's still a shocking termination. I understand the Bolt case is out there. Two of my cases, along with Bolt, were reversed, that this court had actually ruled in my favor. And there are cases, I still think, on the outlier that Bolt allows for review by this court. And it hasn't completely shut it down. It didn't say nothing is reviewable.
Well, counsel, it seems that one of the problems here was not only the issue that this case is all based upon, but the fact that there was also a 2013 disciplinary case. And taking them together, this seemed to be what was concerning to the Department of Education.
Well, I believe the 2013 case was when he was a full-time teacher, and it was viewed as very political, and I think it was a different type of conduct that was at issue here. I think the bigger issue was the 2014 letter he had received that was somewhat similar, but never adjudicated, and there seemed to be a conflation by the arbitrator as to whether that was actually a finding, because that was never adjudicated. There was a letter put in his file, but it was never determined to be accurate or not, and that letter seemed to be the basis for them to say this otherwise would not be termination but for that letter. Part of the problem is the nuance between notice versus penalty, or prior discipline, and in this case, I think that was just used for notice. It was conflated as penalty. If you really look at the specs in this case, it really comes down to one if it's on page 53 of the record, I believe. The arbitrator only dismissed every specification in this case and except for 4 subspecs. And if you read the subspecs, the only thing that you could potentially call actually misconduct might be the failure to provide instruction to the class with work that the regular teacher had left for the class. I mean, he was charged with, stated to the paraprofessional that it's not his license area. Is that misconduct? I don't believe so. You know, he was on a computer. There was no testimony as to what he was doing on the computer. He testified that, and the paraprofessional said she didn't see the computer. So again, I don't think that would be misconduct. So it really comes down to this 4B. And I guess as he explained in this context, he was an ATR thrown into this class. There was a lesson plan. There was no dispute that the students were engaged the entire class with the help of the paraprofessional. And it was out of his license area. And that's really the basis for this man losing a 16-year career. So if there's any room for shocking to the conscience, this might be that case to say there really is nothing here. In fact, Judge Hagler recognized that he agreed that this would not be termination in a vacuum. I believe.
But I guess it was Judge Hagler that also made reference to the opportunity, the situation in 2013, and where he was given some notice that there were some problems, and then the 2014 situation. So it becomes a little bit of a cumulative situation, makes it a little harder to shock the conscience.
Yes, well, I think the 2013 was that was his original school before he became an ATR, and I think it was a different context. I think the arbitrator recognized that there was a very contentious situation, and I don't think it was the same conduct at issue here. I do understand the 2014 letter looks more analogous here, but the question is, he was never charged with that, and he rebutted that letter at the time, so that was never proven. And again, just in the context of, having worked for 16 years, understanding what an ATR is in New York City, as you've probably seen in other cases, to hold someone responsible that there wasn't adequate teaching when the class was behaved throughout the entire lesson. He was charged a year later. They tried to charge him, obviously, and it was all dismissed. I believe this is the kind of case that shocking to the conscience might apply.
Thank you very much, Mr. Glass. You'll have 2 minutes on rebuttal, okay?
May it please the court, Deborah Brenner for the New York City Department of Education. There were a number of misstatements that my adversary has made that I would like to correct, but before I do that, let's just consider that in the wake of Bolt, what we have, where the Court of Appeals did indeed make very clear the limited scope of this kind of review. What we have here is a teacher, a substitute teacher, who has a history of being disciplined for failing to engage with his students and for leaving his post early, who viewed he was unhappy that he was sent to a special ed classroom to teach a science class, which was outside of his area, but there was no dispute that that's what a substitute has to do sometimes. And so he sat there like a war.
But don't you think termination is a bit, 16-year career, this was his second, ostensibly his second violation, his second found, second infraction that was found against him. And
Well, Your Honor,
termination, not suspension?
I disagree, and I'll tell you why. First of all, although my adversary tries to make the point that this was a whole different kind of just misconduct from the first time, it's just not true. Because you need only look as far as the first award, which directed him to take 2 classes. One in engaging with the students, and the other in creating lesson plans, both of which are directly at issue here. But even if it weren't the same kind of misconduct, the fact that an employee just is all over the place, committing all sorts of different kinds of insubordination and misconduct and feeling like he gets to call the shots. If he's not happy and he thinks that he's in the right and the school is in the wrong, that he can just do as he pleases. That is exactly, if you take a look at the first arbitration award, which is very lengthy and goes on at some length and it's complex, but the arbitrator made clear that while there were some political considerations and there was a lot of acrimony that spilled over on both sides, the arbitrator made very clear that Mr. Silvers bore more than his share of the problem, which is why she fined him $15,000. That's no small amount, in addition to sending him for these training programs. So that should have been enough, right? That should have been enough to put him on the straight and narrow. Then he had another instance where he received a disciplinary notice, warning letter in his file about using his laptop in the classroom on personal business. So this is an employee who is remorseless. This is an employee who actually made the argument before the arbitrator that using his laptop during the class to prepare for a job interview isn't personal. There's nothing wrong with that, he said.
Didn't he say that he was only kidding, that he didn't really mean he was looking for using it for a job interview?
He did say that, Your Honor. He said a lot of things, though, and it didn't seem to matter whether they jibed with each other or clashed with each other. At one point, he said he and the paraprofessional never spoke to each other at all. At one point, he said that he was just being sarcastic. At one point, he said, I have a whole list of these things. And he could never come up with an explanation for why this paraprofessional, who the arbitrator found credible, her earnestness really jumped off the page. She blew the whistle on him because she was really shocked at his total abdication of his duty. This was not a teacher who tried and failed. This was a teacher who arrived in the classroom with the intention of being nothing but a warm body. Didn't even go to the office to pick up the packet. Didn't check to see if there was a lesson plan. Didn't check to see if there was an assignment. And he let the para take over. And she didn't even want to, but the students needed help. And they were, in the absence of anybody else to talk to, they turned to her. And he himself said, she's not a teacher. I mean, that's another example of his lack of remorse that he could say, like, is she my supervisor now, Miss Holder? She's not even a teacher. Like, the attitude of just utter, it does not, the arbitrator it's not shocking for the arbitrator to conclude that this is an employee who's not going to change. He has no intention of changing and no form of punishment. Now, it may not have been the penalty that this court would choose or that I would choose, but it's not up to us. The legislature has put this, and the union and the Board of Ed have put this in the hands of a neutral labor arbitrator who makes these calls. Is it shocking to the conscience that a teacher with this kind of history and this kind of extreme misconduct, leaving a student behind in the classroom, 2 students behind in the classroom, without a second thought on top of it all? Is it shocking to the conscience to terminate that teacher? It is not.
All right. Well, I think we got your arguments. Thank you very much, Ms. Brenner.
Thank you.
Mr. Glass, you have 2 minutes on rebuttal.
I take some exception to the allegation that I mischaracterized the record, because I think there was a lot of mischaracterization back. I mean, the testimony about leaving the students behind was that the para was left with her one student, and another teacher had come in. That's not what the record said at all. You also have to understand, this is a 27-year, they're relying first of all, 7 charges were dismissed, so you could question how legitimate this case was, because part of one sub-specification was proven, everything else was dismissed, so that kind of suggests what the motive was here. Remember, this is a guy who it was his 2nd day at the school, or 3rd day in the school. The parapet had been there 27 years, and there's an ATR thrown into the class, and she's the one ratting him out, and this entire case is based on this paraprofessional's opinion about whether he did his proper work in the school. What they're missing is that this man has been satisfactory every year of his career. Every time he taught a history lesson, he was never found unsatisfactory. His teaching was always satisfactory. And so this whole case comes down to one para sort of ratting out her personal opinion about his conduct in the classroom. And we don't know what her motives were for doing that. And there was nothing in the record to suggest that the kids got a project, a lesson. The lesson plan wasn't even developed. He was given a handout. He was a substitute teacher for the day in a class that he's out of his license, that he shouldn't be there anyway. And they're telling him, and now they're blaming him for the insufficient lesson plan, out of license area. And we're going to say Mr. Silver didn't sufficiently engage the kids for 20 minutes when the lesson plan wasn't even there. The testimony was 15 minutes to actually get the lesson plan into the room, which wasn't a lesson plan. So it's just, if you really narrow this down and read the facts very carefully, you're going to realize that this is a complete drive-by, attack on Mr. Silvers. And they actually tried a 7 drive-by, and they got a part of one, and that's the end of his career. And you can understand, if you're a tenured teacher with investment to become a teacher and always had satisfactory lessons, that this is pretty harsh. So I appreciate if you look at the record and decide if this is one of those cases.
We certainly will. Thank you both
Thank you.
very much for your arguments. We will take a further look. The next case for argument is First Equity versus Harmony Group. Appellant, if you would come to the center podium, please.
Absolutely.
Okay, good afternoon. You may proceed.
All right. Good afternoon, Your Honors. May it please the Court. Barbara Siniewski for the defendants' appellants. In the order on appeal, the Supreme Court erred by precluding the defendants from using a substitute expert to complete expert, pretrial, and trial proceedings. The order contains no finding of discovery misconduct by the defendants. The record shows there is no delay
Counselor,
inherent.
I have a question. I mean, ordinarily, maybe I might, I tend to agree with you. Obviously, in these cases, experts are important. But hadn't Judge Cohen warned you several times that these were giving you several adjournments over the year or two in which he was overseeing the discovery and giving you warning that there would not be any final adjournments or any further adjournments, excuse me?
Your Honor, regarding expert discovery, yes, we received one order, and then the judge subsequently issued a further extension at the request of the plaintiff. The other thing that I would say that is different is we were actually on track and complying with the existing order. We produced the first report, we produced the rebuttal report, and our expert was scheduled to sit for deposition until he withdrew. So in that case, this was not a failure to schedule to
Why
meet
did he
those
withdraw?
deadlines.
Why did he withdraw?
He withdrew because of a fee dispute with the client.
Yeah, but it was not unforeseen. It was not unusual or an unanticipated circumstance. You controlled the narrative, so to speak.
I disagree for two reasons, Your Honor. One, the fee dispute really did come up right before he was sitting for deposition. For those months prior, he'd been performing the work. We were talking about going into the deposition. And then it's really not within our control in terms of, it's not my own party. This is a non-party. And to be held hostage to somebody's
Well,
demand
no,
for-
he's not. He's a non-party. You're correct, but he's your expert.
He is.
In
I
some
agree,
way,
Your Honor,
you have
but he is.
control. And what about the plaintiff's? What about the plaintiff's option saying that they will go along with it, but you pay what we've paid so far, because now you have the benefit of our report, and you're going to hire a new expert, which may create a new round of discovery, so that the plaintiff says, if you're going to do that, then pay everything that I had to pay so far for my experts, and we're good to go. And you declined. At least I think you declined. I don't know what happened after that. Because that would have been, I don't think the Supreme Court would have minded that situation where the plaintiff says, okay, fine, we'll just have to start all over again.
Well, in the first instance, that's not part of the order, but in the second instance, the Mataloni case is actually very clear that attorney's fees are awarded for improper conduct, and substituting an expert
No, it
is
wasn't
not an
attorney's,
improper
it's not attorney's
conduct.
fees. It's what they had paid their expert. It's the plaintiff's costs of their experts to date.
Right, but they don't, the plaintiff does not have, the report that they issued stands. They may need to redo a rebuttal report.
Right.
That's the one piece that may be redone. And at the same time, he's already been deposed, so that's already done. That does not need to be
But what,
redone.
but what about the new expert? When, I mean, and since we all sat in the commercial division here, we know that there are depositions of the experts, and couldn't the other side have said, you know, he's taking, your new expert, he or she is taking a little bit of a different look at this case, we would need a further deposition. So there could be some costs that could
Well,
be attributed to it.
Actually, Your Honor, not a further deposition because the expert was never deposed.
Okay.
This would be the first time. And we are asking to provide the requested disclosure under Rule 13 and 3101D so that there is no surprise. I mean, as we stated in our papers, we don't expect materially different
I
testimony.
don't think
This
that,
isn't
I
a
don't
new
think.
area.
I don't have a concern about that. I don't think there's a surprise, because I know that you're going to hire a new expert. That expert, if they're worth their salt, is going to say, I'm not going to rely on the report that you have in your possession, defendant. I got to write my own report now, because that's the way I do things. And then you're going to have to issue that report, and then the plaintiff gets that report and says, whoa, wait a minute, these are new theories. We never saw these theories again. We're going to have to do this. Well, now I got to bring it to my because in the past, the two reports were simultaneously submitted. This time, it's not simultaneous. This time, you get the advantage of seeing both reports and then issuing another report now. So sort of the cat's out of the bag, and you kind of know what's going on, and that, you know.
Why don't you just see if you can address Judge
Right, so that's the
Owing's
concern.
question
Yes.
briefly, and then we'll go from the other side.
Yes, Judge Owing, I don't see that as the situation because, well, for two reasons. One, it's not going to be a surprise theory. Two, if it is, then at that point in time, the availability of a motion to preclude is there. That's the more standard ground, is you come up with a new theory, you come up with a new expert. It's not the question of substituting an expert.
But wait a second, you've been told already, this is a 5-year-old litigation. You've already been told you get nothing more. All you have to do is pay your expert and worry about it later. But you chose not to do that, and you piled on the prejudice to the plaintiff by that choice. And so now you're asking us to hold that the trial judge in this 5-year-old commercial litigation case abused his discretion by enforcing his own order.
I know my time is up, but may I
You
respond?
can, yeah, just respond to that question.
Okay. In terms of delay, there has been no delay, and as of today, there's still no trial date. We have a scheduling conference next week, and in a call last week with Chambers and all counsel, we were told that the court is currently scheduling trials for May 2021. I'm sorry, March 2021.
All right. Well, thank you. You've reserved a minute for rebuttal. Okay,
Okay.
so thank you very much.
Thank you.
If we can hear from Respondents' Counsel, please. Ms. Ryan? Okay, you can proceed.
Thank you, Your Honor. May it please the Court, Rebecca Ryan for Respondent. Your Honors are entirely correct. Whatever prejudice defendants claim here was wholly of their own making. They are before Your Honors because they failed to pay their expert for producing 2 expert reports, and their expert, unsurprisingly, then declined to appear at his deposition. This is not a case where an expert suddenly became ill, or where there were allegations of misconduct, such as lying about credentials, or where there was a previously undisclosed conflict of interest. This is simply that defendants took a risk and made an economic decision to not pay their expert when discovery deadlines were looming in this 5-year-old case. Now, under these facts, where the good cause for an extension of discovery was entirely within defendants' control, the motion court appropriately exercised its broad discretion and concluded that defendants' fee dispute with their expert should not further delay resolution of this action. And in so ruling, it correctly required that defendants bear the consequences of their own actions instead of shifting that burden to plaintiff. And defendants here have set forth no arguments that justify this court overturning the motion court's order.
What about the fact that counselor indicates that there's really may not be any prejudice other than money because everything is kind of delayed these days?
Your Honor, I disagree that there would be no prejudice other than money. First of all, when we're looking at when this decision was granted, or when the motion to vacate was ruled upon, it was February. And 7 months ago, we had no idea that this is what we'd be doing now. At that time, when the court issued its decision denying the motion to vacate, Justice Cohen also set a pretrial conference for March 24th. And so this case was moving forward at that time. Summary judgment motions were also briefed and have been decided at this point. And so to allow any delay that may have been caused because of this pandemic to inure to their benefit, I believe would be unjust.
Does anyone have any further, did you have anything further to say?
I would speak to the different rules under which defendants move, but if there are...
I don't think we need that. Do any of the judges have any further questions?
All right, well then I thank you, Your Honors, and I respectfully urge this court to affirm the decision below. Thank you very much.
Thank you so much, Ms. Ryan. You have a moment, 1 minute for rebuttal.
Thank you. Your Honors, the sole ground on which the Supreme Court ordered was potential delay. And even at the time of the motion, there was no date on calendar for trial. There was no pretrial set of deadlines. And in addition, the schedule proposed in the motion to vacate would have ended on March 3rd, which is several weeks before the conference that was set on March 24th. So for multiple reasons, had the relief been granted, we wouldn't be talking about going back to the Supreme Court and seeking a short adjournment. Additionally, I would urge that, again, attorney's fees or experts' fees are something that generally deals with intentional missing of a deadline, and this just really isn't that. We were all set to go, and then several days before, the expert withdraws. We notify the plaintiff immediately. There's no sitting around. We notify the court immediately.
Well,
We
so
make the request.
I think the implication may have been that in order to, work out an arrangement, they said maybe if you pay us this, we'll give you the time. So sometimes you have, if you are the cause of some delay, you may have to work something out that you might not ordinarily be required to do. It's sort of an agreement. That's how I understood it, but, that's up to you and your client. Anything further?
Your Honor, I see my time is up.
All right, well, thank you both very much. We'll take another look at the file. Have a nice afternoon. Thank you for
Thank
the
you very much.
arguments. The next case for argument is People versus Aaron Johnson.
No? Oh, you skipped 8.
Not KH.
I did? Oh,
48,
KH 48?
oh, excuse me, I apologize. KH 48 versus Muniak. I have just Mr. Gopstein, the respondent, has 5 minutes. I'm sorry. Thank you. Good afternoon, Mr. Gopstein. You may proceed.
Good afternoon. May it please the court, Sheldon Gopstein for the defendant respondent, Sasha Muniak. Your Honors, the central flaw in this appeal is the plaintiff appellant's refusal to recognize that a settlement agreement is a contract enforceable in accordance with its terms, and it supersedes the underlying litigation. Here in July of 2017, the parties entered into a settlement agreement.
But counsel, let me interrupt, I'm sorry. But why do you think your client's entitled to the stay of the entry of judgment? Because I read the stipulation. It seems to be two things going on. Of course, you have your argument saying that you were induced. I mean, part of the reason why your client entered into the settlement agreement was that there was a clause in the stipulation that says that the landlord was going to cooperate with your client to take care of the easement issue. So that was a big inducement to get into it. But then another part of it says you got to pay me X amount of dollars every month or every year, whatever. And if you don't pay me, I'm going to enter judgment against you for your default after I serve your notice. So those are, to me, it seems to be two separate avenues that you have your claim, obviously, on the inducement part, but the landlord has their claim according to the cross motion 3215I. I get to enter judgment. Whether or not he gets to execute it, I think that's another argument, right? But the fact of the technicality of entering a judgment doesn't mean he's going to grab your money. He's just entering judgment. So why should you be stayed?
Because under the Gucci America case that we cite, First Department, a plaintiff should not be permitted to compel enforcement of a settlement agreement, the material terms of which it has willfully breached.
Yes, but why would you move for a preliminary injunction on a money-only issue? That's the problem. Why not just move on any of your... Why would you move for a preliminary injunction? That's the wrong thing to do. This is a money-only case. There's no way that you can show irreparable harm on a money-only case. So why did you move?
Yeah, and to piggyback that, simply you could just move for summary judgment, dismiss the case based on your defenses. I mean, that's what you got, right?
Well, this case had been settled. There were only two obligations for the parties to fulfill in this case. My client was required and obligated to pay money. And as a material inducement, and it says it right there, it's the only obligation that the plaintiff had to fulfill. It was the inducement. It was the only inducement, and it says it's the material inducement to have them cooperate in good faith to remove this easement, and a month later, they did the exact opposite.
No one's arguing that point. I'm saying to you, you can't get a preliminary injunction on a money-only case where there's no possibility of showing irreparable harm. Why would you move that way? Why not, as Judge Oing says, move on your defenses?
Move on. The case was over. The case was concluded.
You were sued on the settlement agreement. You were sued on the settlement agreement.
And your answer?
They were going to enter judgment under a settlement agreement that they had breached.
In this specific case, it was a settlement agreement in this same case. Is
They were going to move, they had sent a default notice. They were going to enter a judgment against my client who would have to live with a $290,000 judgment in a settlement agreement where the other party had breached. I had to come in and get a TRO.
to stop everything so you could litigate whether or not there had been a breach or not?
Why is that
Absolutely.
irreparable harm? That's what I'm keep asking you. How could that possibly be irreparable harm? Getting money, a judgment against you, how could that be irreparable harm?
Because it can destroy his life. To have a $290,000 judgment against him in an agreement where the other party breached, he actually paid $10,000 a month for months and months and months, and then realized that these people were actually undermining the settlement agreement. They had taken affirmative steps to undermine his ability to remove the easement. So he's now being sued in two different cases. He's paying $290,000 to KH48, his prior landlord. He's also getting sued by Maygrant. The whole purpose of this settlement agreement was to stop that.
So I'm sorry. So what happens is landlord sues your client, right? You settle the case with the stipulation, right? That has the inducement in there to settle the case, right?
Correct. The entire inducement.
The entire case. And then what happens is that now the landlord says you default. I want to enter judgment, and you brought a motion to stay that enforcement, and you're saying there was nothing I could do because the case settled. How about then, in the way you look at it, you can seek a vacatur of the settlement, right? Based on the landlord's failure to comply with a condition, right? I mean, can't you do that? Because going back to what Justice Scarpula said, the irreparable harm, it's just all money here. We're dealing with money. But you can move and I've seen this, unless I've been looking at the wrong thing, you can move to vacate a settlement based on a party's failure to comply with a certain condition, right?
But you were saying you wanted to keep the status quo pending anything.
Absolutely. I don't want to vacate the settlement. Why would I vacate the settlement? That reinstates the lawsuit. The lawsuit was settled.
You can't
These
have
were
it
the
both
terms
ways. Hold on a second. You can't have it both ways, though. You can't have your cake and eat it too, because that's what it sounds like you're trying to do here. If you're saying that the inducement was to have the plaintiff help you with the easement, and you don't want him to enter judgment for the amount of monies,
Right.
you got to vacate. The way out. Why would you vacate? Because you got a judgment. The landlord's got an option of entering judgment for the $160,000.
With all due respect, the proper way to do it is exactly what I did. Stop enforcement of the judgment, and I started a plenary action. There is another plenary action now.
Okay.
Where it's in the record, a plenary action where I have sued the landlord for damages under the settlement agreement, and that's what the law says I should do.
It's in the record.
It's in the record. I started a plenary action, but I've got to stop enforcement of the judgment because the other party breached.
Does anybody have any further questions? Okay, we'll take a further look. Thank you for coming in, Mr. Gopstein. Have a
Thank you
good
so much.
afternoon.
Thank you.
Now People versus Johnson is up for argument. May I just ask you, Ms. Boyd, do you want to take 5 minutes and retain one for rebuttal, or you just wanted
I'd
to?
actually like 3 minutes and 3 minutes for rebuttal.
Okay, that still equals 6, so that works.
Equals 6, yes.
Yes, okay, that's fair enough. Counsel, you may,
May it please the court, my name is Laura Boyd, counsel for appellant Aaron Johnson. Mr. Johnson's appellant's equivalency claim is not waived. At no point was appellant told that he could challenge the use of his Maryland conviction on equivalency grounds. Instead, when arraigned on the predicate felony statement, the clerk told appellant,
I'm sorry, counsel, just to interrupt, I just need a preliminary fact cleared up. Did the defendant plead guilty or get convicted in Maryland of that charge?
I believe he pled guilty
He pled guilty, thank you.
to a lesser charge.
Right, I just wanted to make sure that it was a plea and not a conviction. Okay, thank you.
When the clerk arraigned appellant on the predicate felony statement, the clerk told appellant that his 1999 Maryland murder conviction contained all the essential elements of a New York crime, felony rather. At no point did the clerk tell him that he could challenge the Maryland conviction on that ground. As a layperson, appellant would not know that the allegation that the Maryland offense contained all the essential elements of a New York felony was the basis upon which he could challenge that.
but in this case, didn't the defense counsel specifically point out to the court that, and indicate to the court that the defendant waived any issues with respect to the date and did not in any way challenge the prior conviction?
Yes, that's why we filed the 440 to raise it. It was certainly not preserved. I'm not arguing that. But the 440 preserved it. As the Court of Appeals in Juergens discusses, the question of preservation versus waiver are two different concepts.
Okay.
And in this case, if the defendant doesn't know that he can challenge the Maryland conviction on equivalency grounds, he can't knowingly and affirmatively waive it. It would be analogous to, in the case of a defendant who's waiving their right to appeal, if the court told the defendant, when you plead guilty, you waive your right to appeal. The Court of Appeals has said that's not sufficient for a valid waiver. The defendant has to know that he has to voluntarily give up the right to appeal in order to make a knowing waiver of his right to appeal. Same here. The defendant has to know that he can challenge the Maryland conviction on equivalency grounds before you can make a knowing and affirmatively give up that challenge. So in this case, since appellant didn't know that he could raise an equivalency claim, his equivalency claim is not waived.
Okay, thank you. You have,
Okay.
as requested, 3 minutes to rebut. So I'll hear from the district attorney's office. Good afternoon, counsel.
Good afternoon, Your Honor, and may it please the court, Carrie Fulham on behalf of the people. Defendant's adjudication as a predicate felony offender should not be disturbed on appeal. Defendant was adjudicated a second felony drug offender with a prior violent felony offense based on his 1999 murder conviction in Maryland, and Justice Owing, that was because of a guilty plea.
Right.
He declined to challenge that adjudication at the time of his plea and raised no complaint before being sentenced. Instead, he argued for the first time in his CPL 440-20 motion that second-degree murder in Maryland is not the equivalent of any New York felony. He renews that argument on appeal, but that claim is both waived and meritless. Now, turning to my first point, defendant's equivalency claim is procedurally barred. There's no dispute, as you just heard, that his claim was not preserved. However, the Court of Appeals in People v. Juergens states that a CPL 440-20 motion can satisfy the preservation rule, but Juergens also makes clear that an equivalency claim cannot be reviewed where it has been affirmatively waived. And we see that is exactly what happened on the record in this case. After the clerk handed defendant the statement of the violent predicate felony, it was read into the record, and I want to contest something I just heard. Defendant was not told that the essential elements were the same between the Maryland conviction and the New York felony. The record explicitly shows that the clerk said it was alleged that the essential elements were the same. Now, after reading that statement into the record, the clerk asked the defendant if he wished to dispute any charge made in that statement. Asking this question by itself satisfies the Juergens requirements. Now, there was this dispute about the date of the conviction in Maryland, but defense counsel waived that, and he, quote, had no other. At that point, there was a colloquy with the judge, but it's clear that defendant was going to say had no other challenge. But not to be satisfied there, the court took it one step further, to be sure, and said, in any event, there is no challenge. Is that right? Defendant replied, yes, and your honors can see that on page 7 of the record. So we have a more robust record than we did in Juergens, and the waiver was absolutely applied here, and defendant affirmatively waived any challenge. So it is improper for this court to review that claim. Now, defendant is wrong to assert that this is analogous to a waiver of the right to appeal because defendant has to be told specifically.
Let's cut to the chase. Assuming that there was no, let's assume there's no waiver. Is there an equivalency problem here?
On the merits, Your Honor?
Yeah, on the merits.
Yes, there is, and I can go there. Firstly, the merits, there should be an affirmance here for one of two ways. If the court looks to the accusatory instrument, we see that there is a felonious analog in New York second-degree murder. Now, if this court decides not to go to the accusatory instrument, it's irrelevant, and an affirmance should still happen here because the Maryland Court of Appeals has interpreted the second-degree murder statute and came up with 4 various criminal acts that constitute murder in Maryland. And here, in this case, there are 4 equivalent felonies in New York, those being murder in the second degree, first-degree manslaughter, second-degree manslaughter, and criminally negligent homicide. So even on the merits, we have an equivalent felony in New York for defendants out of state felony, and therefore the predicate felony adjudication should be affirmed. I just want to briefly discuss a case I was alerted to moments before. I believe defense counsel will discuss it in her rebuttal. It's Yates versus State. It's not in the brief, but I was just provided an electronic copy moments before, and it goes to the felony murder point under the merits analysis. So I was able to quickly read that, and the holding is basically that, and defense counsel, I assume, will discuss it, but the point is that it supports a finding, an equivalent finding of criminally negligent homicide in New York because the facts in that case demonstrate that although the defendant was convicted of distribution of marijuana, it nevertheless was an inherently dangerous crime because of the facts in which, the manner in which the defendant committed that dangerous crime. So there the court said, quote, petitioner came to the drug deal armed, presumably prepared to use violence should it become necessary in the course of the exchange. When the defendant was then given fake money, he reacted, he gave chase, brandishing his gun. So there we see, and the jury instruction in fact supports this, we see that there was the way the defendant committed that felony was in a manner that was dangerous to human life. And that is equivalent to the New York felony of criminally negligent homicide, because in order to be guilty of that crime in New York, there has to be a substantial and unjustifiable risk of death. To say it another way, committing a felony that is inherently dangerous to human life in Maryland is equivalent to engaging in conduct that creates a substantial and unjustifiable risk under New York law. So there too, on the merits, we have an equivalent felony. I just want to briefly return to the waiver point because defendant does not need to be informed that he has the specific right to challenge the foreign conviction because of the essential elements. So that is a gross mischaracterization of the record in Juergens. And here we even see that in footnote 1. Juergens cites to CPL 421 subdivision 3, which requires the court to ask if the defendant wishes to controvert any allegation. So we have that here. We see that the court asked if there was no challenge. And Your Honor, may I just briefly conclude?
Just briefly, yes.
So the statute continues. If the sentencing court asks that question, and if the defendant does not make any, the statute continues. If the defendant wishes to controvert any allegation in the statement, he must specify the particular allegation or allegation he wishes to controvert. He did not do that here. His claim is waived. Thank you.
Thank you very much. I have 3 minutes for rebuttal.
Very briefly on the waiver, you can't knowingly give up something that you don't know you have a right to raise. And while a layperson should be expected to know the factual allegations of his prior conviction, they're not intended to be an attorney who can know the legal claims that can be raised. So having not known that he can challenge on that ground of equivalency, he couldn't knowingly give it up. As for the merits, I've argued extensively in my reply brief as to why, if any of the 4 different mens reas required for second-degree murder in Maryland if any of those 4 are broader than the New York equivalent, then it's not a valid predicate. I focused on the felony murder because in their reply to the 440, the people noted that Appellate was also charged with robbery of the victim who was killed. We know from Juergens, robbery in Maryland is not equivalent to robbery in New York. So if it was a felony murder based on a robbery in Maryland, that would not be equivalent to felony murder in New York based on a New York robbery. Moreover, the reason why I handed up Yates was only for the point that the felony...
Could you just give us the site for Yates?
Unfortunately, I gave you my only copy of the Court of Appeals, but the
When you say you gave it to us, I don't...
Yeah, they were going to scan it and send it to you. The mid-level appellate court site is 202 MD App 700, it's 2011.
All right.
Yates versus State.
Okay.
And I gave you the Court of Appeals version because the point was, it doesn't have to be one of the enumerated felonies in New York, it could be anything. So if it was a drug deal in Maryland and it went wrong and they got in an argument, the defendant and the buyer, and the defendant engaged in the same exact conduct as in Irby, a case I cite in my reply on page 20, that conduct is not sufficient to establish criminally negligent homicide in New York. But it would be sufficient in Maryland to convict the defendant of felony murder, because if they got in an argument during a drug deal and the person was killed, that would be sufficient. Therefore, you could be convicted in Maryland of conduct that would not be felonious in New York. That's the point. That's the sole point of Yates, is that the broad definition of the underlying felony. I've also argued that the elements, the whether or not the Maryland statute is equivalent to a felony in New York is based on the elements. While 99% of the cases could have facts that would satisfy not only a felony in Maryland, but also criminally negligent homicide, if you compare the Maryland statute to the New York statutes and the elements are broader, it cannot be used as a predicate.
All right, well, we'll take a look at that case. If it was scanned to us, we'll find it. And thank you very much, both of you, for your argument today.
Thank you.
The next case for argument is Empire Center versus New York City Payroll. Counsel, you may proceed.
Good afternoon. Your Honor, if I could, I'd like to reserve 2 minutes for rebuttal, please.
Sure. Okay, go ahead.
Thank you. My name is Scott Shore, and I represent the New York City Office of Payroll Administration. Good afternoon. May it please the Court. With the support of an unrebutted expert affidavit, the OPA met its burden to show that individualized salary information about undercover officers is exempt from disclosure under FOIL. The Supreme Court got that right and correctly denied Empire Center's request for that information, but then erred in ordering OPA to disclose the aggregate data, which Empire Center had never even requested. I first wanted to talk about the public safety exemption and why that made it appropriate for OPA not to disclose the individualized salary information, even with the names of the undercover officers redacted.
Sergeant Matos' affidavit, he knows this stuff pretty good, right? I mean, that affidavit was pretty eye-popping, I thought.
Sergeant Matos definitely knows what he's talking about. He's in charge of the undercover operations for the NYPD, and that affidavit was completely unrebutted. And he explains why it's so dangerous to disclose the information that Empire...
Yeah, because this is, if we were to permit this, this would be every year you could get a FOIA request going forward, probably, right? And that based on what Sergeant Matos has said, looking at the aggregate, you can see how much money NYPD is spending for undercover officers. Because I know the petition is seeking all information or all salaries for people that have been excluded from the payroll. Well, that would now include the undercover, I mean, let's call it what it is. It's geared towards or directed towards getting undercover officers or information about the undercover officers, correct?
That's right, Your Honor. What they seek...
It's looking at the funding. So if the aggregate, you could conceivably look at it and say, okay, this year you spend $200 million. Next year they get the information, they say you spend $300 million, there's an increase of $100 million. And then the next year you have a decrease in that funding so that you can start to get maybe kind of guess through an algorithm what years you're going to spend more money, what years you're going to spend less money. I mean, that's a danger there too, right?
Wait a second, let me ask you how that is different from all the news recently that we just cut $1 billion from the police department's budget. How is it different to say this is a particular thing and it's different from public disclosure about how much the police department budget is, how much it went down last year, how much salaries went down, every other budget, every other piece, patrol officers, that salary gets disclosed, correct? So why is this different? What's the particularized difference in this one?
Right, I'd like the opportunity to explain that. The aggregate data not only shows what the budget is in total, but it also gives people an idea of how many undercover officers there are, because you can divide the total by an average detective salary and get a pretty good estimate of how many there are. But keeping the number a secret has tremendous deterrence value. We don't know whether it's 5 or 50 or 500 or 5,000. What we know is that the bad guys don't know either, and they have to assume that there are a lot. We want them to assume every time they go to sell a drug on the street corner, the person they're selling to might be an undercover.
I still don't understand how that's different from knowing how many police officers there are in general. If you can look at that same information every year and figure out that there's 1 year there's going to be 100 police officers by their salaries, and the next year there's going to be 200 by their salaries, why is the danger different?
The danger is different, Your Honor, because we're talking about undercover officers and undercover operations. We don't want the people engaging in narcotics transactions and terrorism and criminal enterprises to have any assurance that the person they're dealing with is not an undercover officer. If the budget is decreased and we end up with only, 5 undercover officers, which seems impossible, but it would behoove us and our city for the bad guys to think that there are actually several thousand. And if we disclose, hypothetically, that there are only 5, then all those calculations change. Now, when they're on the street corner trying to sell drugs, they don't have to worry so much that the person they're selling to might be an undercover. After all, there's only 5. We know that because Empire Center told us.
The financial information, the budget, the NYPD budget is out there, okay? It's public knowledge, what NYPD, and then you have the OTPS and you have PS breakdowns of all that. What they're looking for here, what this petition is seeking is a specific subcategory of the PS. They want to know how much money you're spending for undercover operations, correct?
That's right, Your Honor.
That's where we don't know. What you have is a generalization of what you're spending for overall operations, but they want to drill down further to see what you're spending for undercover operations. And that by allowing that, that's going to be opening the door to every year a FOIA request for that information.
Yes, Your Honor, that is...
Forget about, you don't want the bad guys to know how many undercovers out there. You don't want anybody to know if the guy they're talking to is an undercover or whether or not who's actually investigating or preventing crime from happening or even terrorist activity out there.
That's right. The uncertainty is a big part of the deterrent value, and that's why.
You don't have a problem with people knowing your budget. You just don't want to know a specific subcategory of that budget.
We don't want them to know this aspect of the undercover budget. They haven't made a request for other aspects of the undercover budget, but I assume we wouldn't want that to be disclosed as well. And other law enforcement agencies take the same position.
This is very different from the DA's investigators.
That's
Very
right.
different, correct?
Well, they haven't shown that the DA investigators are anything like NYPD undercover officers in terms of being recruited from the same pool of people whose information is publicly disclosed every year, in terms of the kind of work that they do. They don't do undercover work exclusively.
You know, a thought just came to mind. The undercover operations also include the counterterrorism operations too, probably.
Yes, they do, Your Honor. And the McWade case from the Second Circuit from about 15 years ago explains exactly how this principle of uncertainty throws terrorists off their tracks. They can't plan if they don't know what they're going to encounter when they are ready to carry out a terrorist attack.
Okay, let's hear from the respondent, and then you'll have 2 minutes to rebut if any of the other judges have questions too. Thank you.
Good afternoon. Cameron McDonald on behalf of the Empire Center for Public Policy. May it please the court, I'd like to start with one question based on the exchange that you just had with counsel for OPA, which is this. What about the public? Why doesn't the public have an interest in knowing if NYP only has 5 undercover officers, especially in these times? I will correct the
Counsel, I don't have a disagreement with you about the public knowing, but what about the bad guys?
So, if I'm a bad guy, and I mean, let's keep some numbers.
Hypothetically, you're a bad guy.
Hypothetically, I'll hypothetically be a bad guy for the day. I'm the narcotics dealer. I'm a street corner drug dealer, or I'm a bookie.
Or terrorist.
I can't look,
or terrorist.
or both, or a terrorist. I can't look at the aggregate numbers and see. Let's keep the numbers at something that might be more realistic. That NYPD's undercover headcount went from 1,000 to 900. I can't tell from that whether or not those people were taken off of narcotics, off of counterterrorism, or moved, how people were moved around. So if I'm the drug dealer on the corner, I have no idea if that person is an undercover officer or not. I don't know what my odds are. So every criminal's playing an odds.
Counsel, the problem with that argument that I just heard is you're underestimating the sophistication of where we live in today in terms of the internet and software. Every day we see, I don't have to, it's anecdotal, but it's probably accurate. They're hacking into computers, they're creating software, they're doing all these phenomenal, crazy things to make life just impossible to be normal. So when you're saying that, you know, if I'm a bad guy, I can't figure that out. We don't know what bad guys do, because if we did, we wouldn't have NYPD. We wouldn't need it because all the bad guys would be gone, right? So what you're saying is an oversimplification of what we're looking at. I have no problem with the public knowing what the budget is. I'm just worried about the bad guys.
So, Your Honor, I'll respectfully disagree.
And then now, your cross appeal, you're seeking individual, you're not happy with the aggregate. You want to drill down further, and you want individualized salaries. That's to tell you exactly how many people are involved in undercover operations, which include anti-terrorism and all the other stuff.
Correct. I agree with that.
Okay.
But I will disagree with Your Honor as far as what anybody can glean from data. I think a
lot of people can glean a lot of things from data.
But we are asking for information.
A high school kid can glean stuff from data, and he tells me some surprising stuff.
We're asking for what the
redacted
taxpayers are spending their money on. Taxpayers want to know what their money is being spent on, correct? And we start with the proposition that taxpayers are entitled to know what their money is being spent on. We don't start the other way. You have to make some really specific and particularized arguments. And so the argument is, if we know how much money we're spending, every bad guy is going to figure out that on Thursday there's not going to be an undercover cop on the street corner. That I have a hard time with, but let me hear your argument.
And so do we. And the problem with the aggregate data is it loses the things that the public needs to know that may be in the mix. So if somebody is getting parked in undercovers, getting some exorbitant salary in their last few years before their pension or something, people would want to know that, because the average kind of flattens everything. You don't know what abuse may be happening. I'm not accusing anybody of abuse, but you know, we're getting these salary records reveals overtime abuse to the MTA. There were all kinds of stories last year from the information the Empire Center got on MTA overtime abuse. So there could be things that happen in that. I commend the court to our
I have one
reply
question.
of
I have one question. We read Sergeant Matos's affidavit. What do you have to challenge that affidavit to say that it's a load of that it doesn't hold water?
It doesn't hold water on just common sense.
What do you have in your record here that shows, or at least contradicts what he states in his affidavit? Do you have an expert telling us? Do you have an expert in security or counterterrorism to tell us that that's not accurate? The answer is yes or no.
There's no expert testimony because no expert testimony was necessary. Experts help with complicated facts. This is not complicated. The analogy,
Well, I mean, the facts might not be complicated, but Matos's affidavit discusses the reasons that he's concerned that this information should not be produced. And he made his point for it. So was there anything other than, you know, well, the facts are, and we're entitled to it, to rebut some of what he said? I mean, he has made claims about certain problems that this information might lead to.
well, he's made speculative arguments about what could be done with the data.
Counsel, I don't mean to interrupt you, but this is serious stuff. Do you have an expert in the security area or counterterrorism to rebut Matos's statement? It's a yes or no answer that's in this record.
We do not have
Okay,
an
that's
expert.
all I need to know.
Okay. Because it's not necessary, because you can look at the information and see the OPA does not rebut the fact that salary information changes, compensation changes, titles change all the time. They don't really connect how you can discern who's who from a bunch of redacted names. And to get to your Honor's point about the security, we're not asking for the information that's going to be sitting on our servers potentially unsecure. We're asking for the information redacted by OPA. And our charts in our reply on pages 2 and 3, you can kind of visualize what that looks like. If they want to give us what's on the chart on page 3, it's hard to imagine how Sergeant Matos' affidavit plays out with that information, because all it shows is lines of personnel and a salary number at the end. You can't figure out who's who from that. You can't add the two together, and we wouldn't have that information because it would come to us.
I think you're,
redacted by
counsel,
OPA.
I don't mean to be glib, but I think you're seriously underestimating the bad guy's abilities. That's all I got to say. I seriously think that.
Well, I'm just to give this one more shot, Your Honor. I'm not sure. If you look at our hypothetical chart on page 3, it's almost impossible to figure out how somebody would figure out who's who from that in the light of how many people retire, move on, and do all kinds of different things when it comes to their police careers.
Thank you very much, Mr. Shore. We will take a look at all those things. You have 2 minutes for rebuttal.
Thank you, Your Honor.
He's essentially saying that I'm being overcautious, that I'm saying I'm chicken little, that the sky is falling.
I would say that Your Honor is being appropriately cautious based on my knowledge of how these operations work and the threats that the public faces.
The relief that Judge Rackauer gave of directing you to disclose the aggregate gross salary of all individuals, is that something that was specifically requested, and is that something that you specifically keep in that way?
It was not specifically requested, and telling the OPA that it had to disclose that information was inconsistent with Supreme Court's rationale that disclosing the headcount would be dangerous, would reveal confidential information about capabilities of the undercover force. I don't know, Your Honor, whether we keep that information in that form.
Well, you are able to tell them that you pay on a bi-weekly basis, and I'm sure there's not a specific document that says that. So I can't imagine that you can't aggregate how much money the taxpayers are spending for undercover police officers and give that number, right? That doesn't seem to you to be something that is nowhere to be found and would take 35 analysts, right?
I would imagine it's all part of a spreadsheet that can be manipulated, Your Honor.
It would be pretty easy to do.
But still, the order to disclose it is inconsistent with Supreme Court's rationale that disclosing that kind of information would be dangerous. I also wanted to note this Court's decision in Grabel, which recognized a FOIL exemption when the disclosure of information would undermine the deterrent effect of NYPD methods. That's exactly what we're talking about here. In terms of the year-over-year data, we don't want the bad guys to see how the numbers change year to year, and we don't want them to extrapolate. Well, last year, the number fell or grew when these things were going on in the city, and based on that, we can extrapolate that next year, when these things happen, the size of the undercover program is going to change in a similar way. And the new redactions that Empire Center has proposed for the first time on appeal are, of course, nothing that Sergeant Matos ever had the opportunity to analyze. If this court were inclined to think that that might be a good solution, then I think a remand so that we would have an opportunity to respond to those new proposals would be appropriate. And finally, Supreme Court should have deferred to Sergeant Matos's unrebutted affidavit about the dangers of disclosing this information, either individualized or in the aggregate. Thank you.
Thank you, counsel, both very much. We will certainly take a look at this further. The next case for argument is Montgomery Realty versus New York City Department of Housing, Preservation and Development. Good afternoon.
Good afternoon, Your Honors. Andrea Caruso from Abrams Fensterman. As Your Honors are well aware, this case involves a 421A abatement request made to HPD. The HPD's denial of that request and thereafter the Supreme Court's denial of an Article 78 review of that request.
Why didn't you file, counsel, why didn't you file the actual application in May of 2018? I understand that you were trying to comply with the regulations with respect to filing the notice of intent. We read the record, we read the arguments. Yes, there was an impossibility of being able to file the notice of intent 9 months before the application. We understand that. But we also understand that you filed your notice of intent a few days before the deadline, which was in May of 2018, within the year after completion of the building.
Right, so the...
What I can't wrap my head around here is why didn't you just file and then see what happens? And if HPD determined that you didn't meet the condition precedent of filing the notice of intent 9 months, then you would have been able to logically explain to them impossibility of performance. But to simply do nothing and let the deadline pass, and the statute is clear that they can't give you a waiver of the deadline for the application. They can give you a waiver, discretionary, as to when you file the notice of intent. So I can't figure that out.
So I think that, and I apologize if I'm yelling, I feel like I'm yelling. The 28 RCNY 51-02D2 says that the application must include either the notice of intent timely filed or a waiver, and we had neither. We did request it, I think it was 10 or 11 days before.
was very close. It was a very short period of time.
It is, Your Honor. However, there's nothing that says that there's a deadline to file that request for a waiver. The entire argument is based on, well, it was only 10 days, but there's no authority that 10 days isn't permissible. There's nothing about the time frame at all. And I think that the denial of it within those 10 days, actually the arbitrariness of denying it when they clearly reviewed the whole thing, and HPD clearly acknowledged or saw that when the notice of intent filing was enacted in October of 2017, we were already past our deadline. We were over a year past our deadline. Our project had already completed, and there was nothing in place regarding all of these filings that HPD was well aware had existed that would come up for 421A abatements in that time period.
But counsel, you didn't timely file your 421A. I mean, was there anything? Unless I missed something, there was nothing to prevent you or preclude you or to stop you from filing a 421A timely within 1 year of the completion. Correct? I mean,
physically stopping me? No, of course someone could have.
I mean, stopping you for whatever. You got some sort of.
Well, the statute does, Your Honor, I believe.
What statute? You mean the city reg? The city reg with the notice of intent?
The 28 RCNY 51-02D2 that says that the application must include either a notice of intent or a waiver of the notice of intent. So it's akin to, and this is not in here, I'm sort of responding, a notice of claim and then filing a case without a notice of claim. It's a prerequisite. It's a condition precedent to it. So just like when we went down and they said, you're not timely, we're not accepting it, it would have been the same thing. We're not accepting. There would be no acceptance of the application. It would have been a futile exercise.
But you answered your question, counsel. In other words, the statute and the regulations allowed you to file the application if you either have the notice of intent or a waiver.
Well, we had neither.
So you could have asked for the waiver when you filed your application in May of 2018 on time, but you did not do that.
Well, because you're correct, Your Honor, but it had been denied the day before. So the deadline would have been May 4th. They denied it on May 3rd. So how is the proposal that we would have re-requested it the next day? They denied it already. So I'm not sure that we have the ability or the right to request it twice. There's nothing to say from HPD that we had the right to request the waiver twice. They had denied it already. And then the whole denial, though, and I'm not disputing, the timeline of that, but the denial was really the arbitrary and capricious decision. Had it been granted within that time frame, we could have filed timely or at least had a chance and maybe we wouldn't be here. The fact that they then waived it months later, almost, I don't know, it's a little curious to me why you would waive it when you're waiving it knowing that the second you waive it, we have no rights to do underneath that.
I have a question, and I couldn't get it from the record, but what's the downside of not getting the obvious thing about not getting the 421A is the tax credits. You're not going to get the crack credits. Are you still compelled or required to have affordable units in your complex to rent them out? Or you go market rate, or they're 100% market rate now?
In theory, no. I don't believe there's a requirement for us to have affordable housing.
Right, so it's 100% market rate.
Whether he is doing that or not, I can't answer.
There's no requirement, because the notice of intent and all that didn't go through, you don't have affordable housing units. You don't need to market.
I don't think we need to. I don't know if we do. I wasn't really prepared for that.
So based on the arguments I'm hearing, you had all this confusion going on with the city regs, with the new city regs requiring the notice of intent that you had to file, right? Or the notice, right? Wouldn't have been, because of all this confusion, didn't you think that the 421A application should have just gone in regardless? I mean, that's a state tax program. That's not a city program.
Like I said, whether
the state did not have that rule. The state did not have that rule where you had to file the NOI before you could get the 421 application in, right?
I'm sorry, you're a little muffled. I couldn't hear that last part.
I apologize for this. This is something for us to get. The state statute providing for the 421-A did not have a corresponding requirement that you had to comply with the city reg before you could file the 421A application. It's two separate entities, right?
The only agency reviewing our 421A
Right.
is the city,
Right.
even though it's created by the state.
Right.
So we have no opportunity to do two separate applications, one to the city, one to the state. Within the confines of the 5 boroughs, you apply through the city of New York and
Right.
only through the city of New
Okay.
York.
Okay.
Regardless of the state agency.
Thank you, Ms. Caruso. You
Thank you.
have, you'll have 2 minutes for rebuttal.
No problem.
May it please the court, Daniel Matza Brown for the respondent. As your honors have pointed out, this case is a simple one. There's a statutory requirement and deadline for the application here that the developer did not meet.
Did you have any discretion to allow them to do this late? I mean, could the agency have said, well, we'll take your application even though you don't have your notice of intent, or, you haven't finished the other thing? Could you have done that? Was there any discretion on the part of the agency?
Your Honor, they did not even try. So I don't know on this particular record, because it's each situation is different. But what we did not have discretion to do was 7 months later, when they actually tried to file it. Right? They claimed that they could not have filed it at the time in May, but because the rules forbid it, they said. But they did exactly the same thing 7 months later. 7 months later, the statute clearly forbid them to put in their application.
And nothing had changed between the expiration of the statute and when they put in their application, correct?
Well, the passage of time had certainly passed.
Other
right?
than the passage of time, no facts had changed.
So, but the passage of time is important, Your Honor, because they were asking for a very expedited review of what's a complicated marketing process, right? So they came to us with less than 10 business days saying, hey, by the way, we built this affordable housing. We want to now market it to the public immediately and make it available to the public. And that's not HPD's role. HPD's role is to make sure that it is fair, that there's a lottery process.
Well, but now you've lost the opportunity to market these apartments as affordable housing, which is what originally they were planning to do, even if it seems that they may have done it late. So now you lost these. I mean, couldn't there have been a discretion? I mean, you kept changing the rules every year or two.
Your Honor, throughout this whole process, they have been asking for tax abatements without ever actually making affordable units available to the public, right? They are still now before this court saying, oh, actually, we haven't actually made any affordable units available, yet we want the tax abatement. That's at every step of the way. They have not come to HPD in advance to do what's necessary in the public interest to make these affordable units available fairly. And they've come in every single time saying, we want our tax abatement approved, and then maybe they will undertake this marketing. But they've never actually done it. It was, just speaking to Your Honor's point about what's changed, my colleague said, it points to the later granting of the waiver, which they kept asking for after they knew the 421A deadline had passed. And the agency was very clear, right, that the deadline had passed for the 421 application, so it would be inconsequential to grant the waiver. It'd be like if I showed up late to the calendar call. I missed the calendar call at this courtroom, and I went to the clerk and I said, please, I know I'm late, but I want to argue, and I'm sorry I missed the calendar call, but my case is up in a few minutes. And the clerk said, I'm sorry, look, your adversary was here, they saw you weren't arguing, they left. And so you can't argue either. And I said, come on, please. And I kept asking, and the judges went home, and it's 5 p.m., and the clerk says, fine, you know what, it's okay, you're late. I'll waive your being late, but at that point, everyone's packed up and gone home. The case has already been submitted. That's exactly what happened here. The agency was being asked to make a waiver that had no legal effect. And so eventually it threw its hands up and said, fine, we'll grant you your waiver, but it does not matter. And that does not mean that at the time when it would have been consequential, that their denial of a waiver was irrational. So the Supreme Court correctly upheld the determination that the application was untimely, and this court should affirm. Thank you.
Okay, thank you. Ms. Caruso?
I have just a few points. The question of saying that HPD said it was inconsequential and therefore they granted the waiver. I don't believe that the record actually bears that out. There's nothing in the record that HPD said that we're giving it to you because it doesn't matter. They actually just say that they're giving it. There's really no conditions to it. And what can be inferred from that is that, well, if you're waiving this, then you're going to continue to hear my application. Why would you grant one without the other? So the argument that they're granting it, they threw their hands up and said it doesn't matter, I think that's counsel's opinion, but that's not what the correspondent that's in the record actually bears out. What Your Honor asked about what changed between. The main thing that changed was the waiver was granted. So whether or not, that's a big thing. You know, the waiver being granted, it's actually, and I've raised it before, it's very curious why they granted the waiver. There's actually nothing in the record that supports what he's saying. There's nothing in the record at all as to why they changed their position, other than they changed their position, which we believe, and had argued at length, that gives credence to the fact that the first denial was arbitrary and capricious. While counsel has made statements that we haven't come in advance, that we haven't said affordability. We did come in advance. We came in April prior to the due date.
When are you claiming that you specifically asked for the waiver? Not when you talked about the waiver, not when you smelled the waiver. When are you claiming that you specifically asked for the waiver?
So Your Honors have the correspondence. I can only see what I can see.
Tell me on the, when are you claiming?
Oh, true. What I will respond to that is that whether it was an explicit response or not, specific.
Well, first let's start with the answer to my question, which is, when did you request it?
The first request for this workbook, with the telling them that it was untimely and that was in April. But there's nothing explicit, Your Honor.
So I'm asking you,
correct.
When did you specifically ask for the waiver?
What you see is what I see. I don't know what phone calls transpired. I can't assume. What I know, based on the record, there was an explicit request over the phone in August when HPD changed their decision. What I can say, and I really don't mean to be dodging around, it's just my understanding is a little different, is that whether there was an explicit request or not, which is HPD's argument, HPD took it as a request because their response on May 3rd is we're not granting you the waiver. So whether or not it was explicit, HPD understood that our request was a waiver, explicit or not, which I do not see it explicit. I will concede that. But I believe that HPD understood it to be a request because their email dated May 3rd specifically says we're not granting you a waiver.
Counsel, in your brief, and I may have missed it. In your brief, and I may have missed it, was there a specific case or appellate case that would have allowed HPD to waive the statutory deadline set forth in this statute? In other words, when you were required to file within 1 year of the building completion, and there are other laws similarly situated with mandatory deadlines. In order to establish whether HPD was arbitrary and capricious, did you brief a particular case that would have allowed them to do this here?
No, Your Honor. The arbitrary and capricious nature is not necessarily the denial of the application after the date because there was this condition precedent. Our real main argument is that the arbitrary and capricious was the denial of the waiver request, which made it impossible to actually timely file. Whether or not it could have been done, it was impossible. Once they denied the waiver the day before it was due, it was done. The only option we had was to challenge, which is what we have opted to do here.
Okay, thank you very much.
Thank you, Your Honors.
both of
Have a
you.
wonderful day.
Have a nice afternoon. The next case for argument is McCormick versus NYU Langone. Counsel, step up to the podium. Good afternoon. You may proceed.
May it please the court, Stephen Gerber, Schumann, Updike, Kaufman, and Gerber for NYU Langone, NYU Hospitals. Your Honor, I submit that this is a rather straightforward case and that the trial court respectfully got it wrong for 3 reasons. 1, a 741 New York labor law claim requires but-for causation. The statute itself, can Your Honors hear me?
Yes, fine.
The statute itself uses the word because, similar language in 740, a related and earlier statute, and one cannot retaliate unless one has knowledge of the protected activity. Second, and the flip side of it, in order to meet the elements of the claim under 741, the plaintiff must complain to a supervisor or higher authority before proceeding to the external complaint. That was designed particularly for healthcare institutions.
Didn't the plaintiff make these allegations sufficiently in her papers? I mean, I guess you think not, but it seems that she had made some statements that other people knew, that she talked to other people about this. It was very close in time. I understand that, but doesn't that at least raise issues of fact that don't let us make a decision on this motion?
No, Your Honor, respectfully. She testified at her deposition. She never told any supervisors or management. She says she told her union people about it a day or 2 later and some coworkers. She never told them, never told management about it. But that's a 2-part test, Your Honor, if you read the statute. The statute says in 741 sub 3, the protection, which is 741-2, because of protection, shall not apply unless the employee has brought the improper patient care to the attention of a supervisor, that's not her coworkers, and 2, afforded the employer a reasonable opportunity to correct it. Critically, the statute goes on. This subdivision, i.e. the report and allowed to correct, shall not apply if the plaintiff establishes a 2-part and conjunctive test. 1, the improper patient care presents, quote, an imminent threat to the public or the patient, and to the employee relieves in good faith that reporting it wouldn't matter. There is no evidence in this record that after the injector nodule was changed within 5 or 6 minutes, that there was any imminent danger to the patient. Indeed, the uncontradicted record is to the contrary. The affidavit of David Wayne makes it plain that there was not an ongoing danger to the patient. The pediatric patient was receiving nitric oxide instead of through the machine by what is called an ambu bag. The doctor was manually bagging the patient and inhaling it. 3, there is no question but that the decision to terminate was predicated on grounds other than the alleged Department of Health May 22 complaint.
Sir, doesn't this record have a dueling positions? You have Mr. Wayne's position versus the plaintiff's position as to what was transpiring on the particular day and issue that was the subject matter of the complaint.
No, respectfully, Your Honor, there's 2 positions. The correct position in which, at least in this world, other than under Einstein's theory of relativity, time is linear. On May 21, the event occurs. On May 22, plaintiff alleges she complained. The Maxine Simon affidavit, chief regulatory officer of the institution, makes it plain that when DOH comes on a allegation investigation, as they did on June 1, they do not know who complained or what the complaint was. Between May 21 and the morning of May 29, the conduct was investigated. People were interviewed, memos were written, Signed statements were given. At 12 noon on May 29, demonstrated in the emails annexed to the Eng affidavit, a senior IT person, Mr. Catanzaro's colleague sent an email saying she is being terminated as of 12 noon. There's an email back saying she is terminated as of 12 noon. May 29 is a Friday. June 1 is a Monday.
How about the anonymous call?
The three reports, Your Honor, the first two are of no moment. They talk about age. They talk about not being liked because she was more knowledgeable. Those are, by the way, reasons for retaliation.
I don't.
May 30th? May 30th is a Saturday, Your Honor. The decision was made on Friday. The
One second. You say that as if it's a fact. Did the person who supposedly made the decision, did that person put in an affidavit at all, ever?
That person
I made that decision on that date.
Well, Your Honor, that person was subpoenaed for deposition by the plaintiff. Mr. Catanzaro at that time was no longer employed by NYU Langone. He did not pursue that. That person, though, Your Honor, and the testing of the decision is not tested on a basis of whether we have to show that each and every fact, 20/20 hindsight, months later, is correct. You have a Wayne affidavit. You have statements from Wayne at the time.
And there's a disputed issue of fact as to that. The letter is dated 2 days later. And you say, so here's a letter dated 2 days later, and you put up some hearsay, not from the person who made the decision, that shows it was made 2 days before. So how could we possibly make that decision on summary judgment?
Because, Your Honor, the decision was made on May 29. That June 1 letter, Your Honor, was sent to the HR person who communicated with that person as the decision was made. It is the same letter. The date of the letter was the date on which she was going to be back at work. But she had been terminated on May 29. The decision was made. The emails back it up. The hospital's records back it up.
All right. No, some of the records don't back it up. That's the whole point.
The only
The
record...
letter is dated 2 days later. That doesn't back it up.
Your Honor, the only thing that you can say is 2 days later is the date of the letter. But the letter is attached to a May 29 email at 2 in the afternoon saying, here's the letter we're going to give her on Monday. At 12 noon, she's been terminated. Her pass has been eliminated. Her email has been eliminated. She is being terminated. She is being brought in to get the letter. She has been terminated. The decision was made. That's the point. The decision was made. Secondarily, there's no evidence.
Finish up. You'll have 2 minutes for rebuttal.
Thank you, Your Honor.
Thank you. We'll listen to Mr. Brody, and then we'll hear back from you, Mr. Gerber. Thank you.
Thank you, Your Honor. Scott A. Brody for the respondent, Victoria McCormick. Justice Billings addressed each of the points that counsel began.
What about the point that Mr. Gerber made about the fact that on May 29th, that was really the date of the termination, and they attached the letter just to say this is a letter she's going to get, but you know.
So as to rebut the anonymous call that was made on May 30th.
Well, 2 specific points to answer that question. So let's suppose the decision was made on May 29th to terminate her. They would then have to say that management did not know at that time that she had filed a complaint as a whistleblower. They claim they first knew that on June 1st, which is the following Monday, when the agency came in to do their investigation. But we know that's not true. How could an anonymous person know on May 30th? He says it's Friday and Saturday, so they made a decision on Friday, and on Saturday, somebody files a complaint saying 2 very important things. 1, Vicky is being terminated on Tuesday, the following Tuesday. How did this person know that if they weren't privy to the decision-making process? The letter wasn't written yet terminating her. That's dated on Monday, and she wasn't terminated in person until Tuesday. So how does the person know that? 2, Vicky was the whistleblower in regard to Jim's neglect. So the person who sends this in on Saturday, before the letter is written, is privy to the two most critical pieces of information. She's being terminated, and she's the whistleblower. And yet counsel says there is no question of fact that they knew that she was the whistleblower at time of termination. That's not feasible. Let's go one step further. In order for the plaintiff to succeed, she has to show that there was a retaliatory action when they knew she was a whistleblower caused by her being a whistleblower. How about the fact that when she goes to the grievance hearing, they clearly know she's the whistleblower at that point. They have letters to that effect. They've been investigated to that effect. They have a hearing officer who finds two important pieces of evidence. Both of them become rejected during the course of the hearing, and he upholds her termination anyway. There is no basis upon which on this record a court could say that the upholding of her termination came at a time that they didn't know that she was a whistleblower. And if you read their brief, they say unequivocally, the post-May 29 events cannot change the fact that she was terminated because she had endangered patient safety. Yet the hearing didn't find that. The only two pieces of evidence were rejected. So there was no basis for her termination for endangering patient safety because she
And the
never...
person that knows a lot of this is not here or doesn't have an affidavit from them.
Not only did Mr. Catanzaro not testify because he's no longer employed by the hospital, the person who Ms. McCormick said was the person who endangered patient safety quit 2 days after this incident. Mr. Wayne was terminated shortly after this incident. So the three supervisors, who, by the way...
Didn't Mr. Wayne change his story at some point during this process?
He changed who handed Tara the infected module, and he investigated, and Mr. Catanzaro investigated their own conduct. HR got these complaints that said, Mr. Catanzaro, your department has bad morale and you endangered patient safety, and handed it to Mr. Catanzaro and said, you investigate your failures. Okay? And this case amounts to this. According to NYU Langone, unless you can hand us a memo that said we are terminating her because of her being a whistleblower, then you can't find us guilty in that regard. There is so much evidence in this case of the conduct that they engaged in, but I don't have the smoking gun, at least not yet. But there is no basis. Justice Billings went through all of the evidence. She issued a logical and reasoned decision that entitles my client to a trial. Let them prove their case at trial. Thank you, Your Honor.
Thank you very much.
I'm going to be very brief.
Sure.
This is clearly documented in the record. On June 1, when the Department of Health came to Langone, nobody at Langone knew about the protected conduct. The protected conduct is not calling her a whistleblower or that they're stupid. The protected conduct under this statute is singularly reporting it to the New York State Department of Health. Number two, what does she claim in her complaint is the incident that she reported. I direct the court respectfully. I believe it's paragraph 48 of the complaint. It talks about the May 21 incident. It doesn't talk about Jim Weatherby in other things or other things he may or may not have done. Three, David Wayne gave an affidavit. David Wayne was identified. Plaintiff chose never to take his deposition. There's nothing in the record, and I would say of personal knowledge, David Wayne was not terminated. Four, calling somebody a whistleblower does not qualify them under this statute. What qualifies them is engaging in the protective conduct of reporting to the regulatory authority and allowing the company, the healthcare, the hospital, to respond. And we had that right. We were not given that right, and the case fails as a result of that. Even if you accept that she had a good faith belief that something wrong went on, there was no imminent danger on the morning of May 22 to that patient. She can't meet that test. For that reason alone, it should be reversed. This court sits with the entire record. On the hotlines, Wahhabi's, I think it's page 1418, what is the record, or the hotline records, her deposition testimony, she's the one who receives those reports. She didn't get it until the following Monday. She investigated it. The fact that there's a union grievance under a CBA is of no moment, not admissible, doesn't bear on this. It's as if saying 2 years later you found out that you should have done something differently. But even if it is, the hospital's entitled to accredit other witnesses besides Ms. McCormick in a union grievance. The test is not, as a super personnel agency, should this court or indeed a jury sit in judgment of whether the hospital did everything possible to investigate it and make the decision about terminating. The issue is, was that their reason or only action here? Did they do it because they knew she complained to the Department of Health?
Okay, thank you very much, counsel, both of you. Thank you for your arguments. Have a good afternoon. The next case for argument that should get ready is Atkins versus Metronome Events. Counsel, you can come over to the podium. Okay, you can start.
May it please the court, my name is Stephen Sledzik from the law firm Morrison Law Firm PC in White Plains, here on behalf of the appellant, Robert Pereira. This is a case where there are two issues on appeal. It's the quality of the conduct of the trial and the quantity of evidence in the trial. We are seeking reversal of the trial court's decision, which denied the appellant the opportunity for a mistrial and also refused to find that the jury's verdict was against the weight of the evidence.
Sir, on the record below, would you not agree that there was really no objection among other concerns raised on appeal to the actual verdict interrogatory on behalf of your client?
I think the appeal is broader in scope than just the interrogatories itself.
But isn't that one of the major issues was that your client was not an employer, and the jury arguably didn't have an opportunity to address that issue and sort of separate him from the people actually supervising, controlling?
That's one of the issues, Your Honor, but other
So
issues...
that's
other
my
issues,
point.
No, but I want to respond to it. I want to say that there were issues that were preserved for the appeal. There was a motion for a mistrial, and there was a motion that the jury verdict was against the weight of the evidence. And the motion for the mistrial relied on the issue concerning the complaint going to the jury, and the trial court, in ruling that the complaint going to the jury was not prejudicial, raised the issue of her curative instruction, which was really tepid and lukewarm, and failed to really address the issues concerning the complaint that had gone to the jury had for 2 days. With respect to Mr. Pereira and Mr. Pereira not being an employer, there is authority from the Second Circuit. That's the Hutchinson case. It's the November 2019 case that I cited that deals with the interpretation of the Second Department. And I understand we're in the First Department. I get that. The Second Department's interpretation of 4404 that issues in terms of grounds for a new trial can be raised in the absence of taking an exception at the trial court. And also this court has said in the Rivera case, Rivera versus W&R Service Station, Inc., that reversal is required if no exception is taken, if the error is such a fundamental character, the resulting injustice is so egregious that the reversal is required in the interest of justice. With respect to Mr. Pereira being an employer in the trial court, there was no evidence that he would be an employer under Article 6 of labor law. Mr. Pereira was identified solely as being one of the partners. The extent of his ownership interest was never, there was no testimony as to the extent of his ownership interest. It was indicated that he oversaw the concepts of events.
Okay, counsel, this wasn't really raised at trial, and wouldn't this be a legal issue that maybe you would have made a motion for earlier along in the even before the trial? And either he was an employer under the
It's something,
law or not?
Your Honor is correct. There's various points where it could have been raised. It could have been raised on a motion for summary judgment. It could have been raised on a directed verdict. It could have been raised on a directed verdict after trial. Those would probably be the more critical points, but the failure to have raised that, again, under the Hutchinson case and under Rivera, it can still be raised here. But I think more compelling, Your Honor, is the prejudice that there was to the appellant, Mr. Pereira, by the fact that the complaint went to the jury. The jury had the complaint for 2 days. The complaint is a one-sided...
There was a certain amount that was demanded in the complaint by the plaintiff, and the jury didn't come in with that amount. I mean, they had calculation sheets, I believe, as to how they figured out the damages, and they didn't just say, oh, the complaint wants this, they win. They did their own calculation. So how else... What was the prejudice there? I was trying to understand what was
well, Your Honor, you're focusing, like the trial court did, on one line from the complaint. And the trial court focused on 2 lines from the complaint in terms of the ad danum clause with respect to attorney's fees and penalties. But the complaint is a 20-page document. And in the complaint, the term automatic gratuities and service charges is referenced 12 times. There's allegations that the respondents engaged in tax fraud. There's allegations about the respondents' financial wherewithal. There's allegations related to wrongdoing and deceptive business practices. There's also 2 causes of action in the complaint.
Again, what's the prejudice? The trial judge gives at the beginning of the action and the end of the action and 37 different ways during the action a charge that the only thing that the jury is supposed to look at is the documents moved into evidence and the testimony at trial.
The jury doesn't know that that the complaint hasn't been moved into evidence. The jury asks for all the documents that are in evidence. That's on page...
How do you know that's true?
That's on page 842 of the complaint. I'm sorry, 842 of the record.
What do you mean?
The jury gets the entirety of the exhibits, and that includes the complaint. The jury's not sitting there with a checkbox saying this came in at this time and this came in at another time.
How do you know?
And they look at that. They look at that 20-page document with
Counsel, can I suggest that when the judges are asking a question, even if you're in the middle of the answer, it would behoove you to stop and let the judge ask the question. Okay?
Absolutely, Your Honor.
I know it's hard to hear.
I apologize.
That's a good suggestion.
It's a great suggestion. I apologize, Your Honor.
No problem.
I just want to know why you think the jury didn't pay attention to the judge's directions.
Because the judge's instruction was limited and myopic. The judge's instruction, curative instruction, after the jury had been with this scandalous and prejudicial complaint for 2 days with baseless allegations about deceptive business practices, the judge just told them, ignore costs and ignore statutory damages. That's it. It doesn't translate to the jury that they have to ignore the complaint itself. And some documents are in and of themselves prejudicial. We cited many cases in our brief related to things like where juries take in dictionaries or internet definitions of terms. Essentially, that complaint was the plaintiff's definitional section in terms of damages.
Well, I just want to say that a lot of times in a trial, an answer is given by a witness, and the court instructs the jury to please disregard what the witness said. Now, we have to hope that the jury listens to what we say. It's tough to disregard what somebody just said, but that's what we have to do. Otherwise, every trial would end up with a mistrial because stuff happens in the course of these trials.
But that's not one line of testimony, Your Honor. I just want to respond to your remark, and then I will save my time for rebuttal. It's not just one line of testimony or a couple of statements. It's 20 pages of baseless allegations. There's 2 causes of action in there for violations of deceptive practices law and unjust enrichment, and the jury really was not able to sort out the difference between the decision they were making and the allegations in the complaint.
Okay.
Certain documents are in and of themselves so prejudicial. It's the plaintiff's one-sided statement of its case.
Okay, thank you. You can save the other comments for rebuttal. Counsel?
Good afternoon, Your Honors. Jonathan Warner for the respondent, Robert Atkins. The corporate defendants unlawfully retained tips and gratuities intended for respondent, a bartender, in violation of the New York labor law from 2009 to 2013. Appellant admitted at trial that he was the owner of the corporate defendants. Appellant's witnesses stated at trial that appellant was the employer. Appellant did not dispute in any manner that he was the employer. He failed to object to the jury instructions, which did not include a statutory definition of employer because it was so plain. This case wasn't tried on that issue, Your Honors. He admitted it. He failed to object to the verdict sheet, which lumped him with the corporate defendants as the employer.
What about the complaint? Was the fact that the complaint was allegedly in the jury room while the jury was deliberating?
Your Honor,
how prejudicial was that?
It wasn't prejudicial at all, Your Honor, for the following reasons. Appellant got a fair trial. Yes, the complaint demanded $375,000. The jury gave my client $143,000. Clearly, the complaint didn't overawe them, let's put it that way. But more importantly, Your Honor, when the judge below learned that the complaint was there, she gave curative instructions, and they were not objected to. And the jury cut the damage award, with this, it falls down. The jury cut the damage award by more than half. It went from $143,000, even though the complaint wanted $375,000, it went down to $66,000 based upon the curative instructions, Your Honor, which were not objected to. The principal argument which the appellant made below was that the jury's decision was against the weight of the evidence. And in fact of the matter is, he didn't object to any charge, and he didn't object to the verdict sheet. And under this court's ruling in Beta versus Port Authority of New York and New Jersey, and under the CPLR 4110-B, he missed the boat. He just missed the boat. Now he comes to you and says, oh, it's against the weight of the evidence. My client was so prejudiced. But it simply wasn't the way this case was tried. Below, he claimed that there was a problem with the alternate juror, and there was a problem with the verdict, but there was no objection to the new verdict sheet. He had a new verdict sheet. The judge realized what had happened when she talked to the jury, that they had this complaint. So she had a second round, and she gave a new verdict sheet, and that new verdict sheet eliminated the issues that he's complaining of with respect to the complaint. And I might add, Your Honor, that it just burns me up that I hear in the brief like 4 times that the jury had the complaint for 3 days, and here in front of Your Honors, they had it for 2 days. This case went to the jury on a Friday. The jury was not in session Saturday and Sunday. The jury came back on Monday and had the jury verdict, I believe it was before 1 o'clock. And the reason I know it's before 1 o'clock, actually, I don't believe it, is because there was an issue as to the alternate juror getting lunch. So this jury didn't have this complaint for that long. There was a lot of evidence in this case. And yes, that complaint, Your Honor, no excuse, shouldn't have gone to the jury. But it didn't prejudice this trial. This defendant got a fair trial. And he may not accept that the jury rejected his witnesses, but this isn't, and he states in his brief, oh, there were 6 witnesses. Well, yeah, there were 6 witnesses, but the jury rejected much of their testimony. What they did credit was the testimony by his own witnesses that this man was the employer. He headed up the shop. And they so testified, his own witnesses. The judge below, Your Honor, said that there was a valid line of reasoning and permissible inferences which would have led the jury to conclude that the patrons would not have interpreted the service charge as a gratuity. At the heart of this case is his clients, corporate defendants, adding 20% service charges to the bill and never giving that to the bartenders.
And there was a lot of testimony from a lot of different witnesses on that point, which was the main
Judge, there were
point
at
of
least 8 witnesses who offered testimony on this issue. And the 2 witnesses for my client were believed, and the 6 witnesses for the corporate defendants were not believed. And it's as simple as that. The jury did not base their award, the jury did not base their award on the complaint. If they had, I'd be here with a $375,000 verdict instead of a $66,000 verdict, which again, as I said, when the judge gave her curative instruction, there was no objection, and no objection to the second verdict sheet. And then, and that should end this discussion, Your Honor. He lost his chance. And I ask that you affirm the judgment.
Do any of my colleagues have any other questions? Okay, thank you very much. We'll hear from you, counsel, if there's any rebuttal.
Your Honor, the standard in this court, dating back more than 100 years in terms of the consideration of extraneous documents, are that they void a verdict. And there's a 1939 case we cited in our brief, Public Operating Corporation versus Weingart, that sets a high standard that the respondents are ducking. It says, unless it can be shown that the jury could not have been influenced by the extraneous material, or that they might have been influenced by the extraneous material, the verdict should be overturned. And the verdict should be based on the actual evidence, competent evidence subject to cross-examination.
Well, counsel, I mean, this is why we require here, or we require under our law, that if there are these issues, that you raise these issues and
these were the primary
preserve
basis.
them, and preserve them for appeal. Because there's an opportunity to take care of these issues when the jury and everybody is still there. If there is a problem, you felt that the judge did not appropriately give the curative instruction, could have discussed that with the judge at that point further. So maybe she might have added something else, maybe not, but at least you would have preserved it. Come up here now, after very little of that was discussed below, to throw out the case after the judge spent a lot of time in this trial, it's,
Your Honor,
it's like hindsight. Sorry.
This was preserved, Your Honor. There was a motion for a mistrial made orally immediately after it was indicated that the jury had had access for 2 days to the complaint. And there was paper submitted after the trial where it was
And then
briefed.
didn't the judge give the curative after that was brought to her attention? And there was no objection to the curative, correct?
There's no objection.
So then what else now? So you tell her, she does what she thinks is right. You don't object any further. And now on appeal, you want us to throw out the entire verdict?
This curative instruction, Your Honor, for starters, certain documents are so prejudicial, even with a curative instruction. And a 20-page, one-sided, inflammatory recitation of claims not in evidence, causes of action, not even voted on, not even given evidence to, is that case.
Again, when she gave the curative at the time, did your party say, that's not sufficient?
I cannot say they've done that, but under the Rivera case deals with the failure to object to a curative instruction. And this court considered that and ruled on it despite the fact that there was no objection to the curative instruction. And it can do that again in the interest of justice where fundamental rights are violated. And that's what happened in this case. Okay. This court should reverse the lower court for that very reason. Thank you.
Thank you, counsels, both of you, very much for your arguments. And I hope you have a nice afternoon. The next case for argument is Pieternel versus Smiley and Smiley.
Good afternoon, Your Honors. And
Good afternoon, Ms. Rubin. How are you?
I'm well, thank you, Judge, and it's nice to be back. It's been a long while.
So I have a lot of questions to ask you here. I am really very confused. So perhaps you can help me. First of all, did you ever read the decision that came from this court in June 2020 on the related appeal?
Yes.
Because it seemed that, I mean, I know that this appeal was briefed before that, but it sort of seemed like everybody is kind of ignoring it. Do you have anything different in your argument because of having read this 2020 decision after you briefed it?
Yes, there are a couple of things that I want to bring up to date for Your Honors. The first is that at the beginning of my reply, I indicated that upon information and belief, the case had been transferred along with In re Verdugo to Judge Kelly. I was mistaken, it turns out, and I don't know when this occurred, but it is this case, Peternell, is before Judge Lawrence Love.
Yes, I checked that out.
I have no indication as to when that occurred, but it is with Judge Love. The second thing is that something that is not in this record, but was in the Verdugo record, in this record, every time we see a reference to the stay that's at issue on this appeal, there is a reference that says, the stay shall remain in effect until the, until the Peachtree matter is resolved. The Peachtree matter...
Isn't the Peachtree matter what everything is really about? I mean, it all comes down one way or another to the Peachtree loan. That's what the personal injury case is long since settled. The guardianship, there is a guardian, although honestly, I'm not sure who the guardian is because every time this attorney shows up, it's a different guardian, so I can't figure out who the guardian is.
I think I can help you with that too.
And I don't know why you don't change the name of the case to have the right guardian there. But what's really out there? So the guardians have been appointed, the personal injury case has been settled. The only issue is an allocation of fees between your client and the incoming firm Schwartz, somebody in Campisi. There's an allocation of legal fees, and it's all based on the Peachtree funding. I mean, what's going on here? What are you spending years and years and years on this when that's what's left of these cases?
Well, because some 6 years after the attorney-client relationship ended by the stip that was at issue in Verdugo, and that will be addressed in the fee hearing, 6 years later, the then guardian commenced this legal malpractice action against Mr. Flommenhoft and his prior firm, Flommenhoft and Canada. It does, again, arise out of the issue of these Peachtree loans, but this is a malpractice action, alleging fiduciary duty and so on and so forth and other malfeasances. But basically, it's the same storyline that you heard in Ray Verdugo back in May when we argued that. The question is, should this stay continue in effect? The Peachtree matter has resolved. It was settled. Mr. Verdugo, his guardian, paid back the loans.
But isn't Peachtree still suing your client?
No. No.
Your client got some of the money.
No. The money that he retained, the portion of the money that he retained, he didn't retain it for himself. It went to pay the expenses of the still then ongoing litigation, the personal injury litigation. And in fact, I think the Verdugo record showed that he was still I can't remember which number was paid and which was underwater, but I think he was still some $30,000 outstanding that he hadn't been reimbursed.
Counsel, just so that I'm clear.
Yes,
the
Judge.
settlement of the Peachtree matter extinguish the the third-party claim that Petrie has to get back the difference between the $55,000 and the $80,000 and change that was actually on loan?
Yes. As between Peachtree and Mr. Flummenhoft and his prior firm. I believe that the guardian reserved rights to then turn to Mr. Flummenhoft, which may or may, yeah, I believe is at issue here in the Peter Now matter. But the question is whether or not, and I do notice that my time is up.
Well, I want you to answer.
Please, yeah. Is to allow this to go forward so he can defend himself on these claims. These are very serious claims of malfeasance against an attorney.
Well, we told you in this decision that we issued, Judge Oing and I and two other of our colleagues, in June of 2020, we told you that you should go ahead, that Mr. Flummenhoff had to provide certain discovery and that you should go on and have a hearing.
Yes.
What's going on with that? Are you doing that?
There is some motion practice ongoing at this point. I am not involved in that, but that I believe that Schwartz Goldstone made a motion to go forward with the discovery. Mr. Flummenhoff made a cross motion to limit the scope of the discovery. And the concern...
Didn't we already decide that, or you started that? No?
I'm sorry?
I thought we decided that in June, but I guess you decided to make other motions.
You know, counsel, by you saying that, when you said the Peachtree proceeding is settled, it's over, this June 2020 decision is arising out of the Peachtree proceeding. So it's not over, it's still alive and kicking.
Well, no, as between Peachtree funding and the Guardian and the IP, that has been resolved.
Ah, that's the key, right.
And the third-party action brought by Peachtree against Mr. Flummenhoft and Flummenhoft and Canada, that no longer exists.
Right, but this order, this decision we issued is still valid, right? I mean, because...
No question, absolutely.
Okay, so
absolutely.
The fact that, so there's still a live issue with respect to the fee that Mr. Flummenhoff is arguing he's entitled to, because the firm, Schwartz, is saying, no, you're not entitled to that because of whatever, and he's relying on the stipulation saying that he is entitled to it because of the charging lien.
And so, the hearing is to thresh that out. Absolutely.
So when you say it's settled, it's over, it's really not settled and over. There's still this Peachtree line here is still, we got a peach that's running around.
So that hearing still has to be held within the contents of the
stipulation, yes.
Yes, but that exists in the context of the guardianship proceeding.
Yeah.
And
unfortunately, yes.
Unfortunately, I'll tell you, I wish I could just say these cases are consolidated. Go back and I don't know why there was a motion to consolidate it.
That would be great.
I would like to do that. I'm not sure I'm
Please,
allowed to do it.
Your
I'm
Honor,
going to try to figure out a way to do that, because that's what makes sense.
If procedurally this court could do that, we would be thrilled.
Did you ever hear of
have it all in
stipulating
one
to things? What's the matter? Can't you stipulate? There's the other attorney, and
He's right there.
Go consult. All right, sit down, Ms. Rubin. Let me hear from.
If I could, okay.
No, you can. I'll give you. Well, no, you don't have another minute. Just if I have another question, I'll call you up, because I really want to do the right thing here, but I'm confused. Let the other attorney come up.
Thank you.
You're Mr. Vera?
Yes, Your Honor. Good afternoon.
So, who is the guardian in this guardianship case? Who is the guardian now?
Your Honor, I represent the successor guardian, Roberto Lopez, the respondent in this appeal. He is the successor guardian of the personal needs and property management.
That's what I thought. The wife is no longer a guardian at all.
Correct, Your Honor.
So why don't you change the name of this case?
Since the successor guardian's appointment, this malpractice action has been stayed. Therefore, no action has been taken to substitute and amend the caption. Upon the lifting of the stay, of course, we intend to do so, Your Honor.
Do you have anything to do with that? You don't. Do you have anything to do with that fee hearing?
Well, we have been permitted to interject initially the appellant's former counsel, Robert Plotz, allowed us to interpose papers in that proceeding, given our interest in this malpractice action. In the context of the fee dispute, the appellants had argued that their alleged charging lien barred any claims of malfeasance and malpractice. As Your Honor noted, by virtue of this court's decision dated June 11th of 2020, this court held specifically that a hearing is required in the context of the fee dispute to determine whether cause existed.
I know what we said.
So essentially, hold on a second. So essentially, in the guardianship proceeding, the law firm SGC is essentially fighting your battle because they're saying, I'm not giving Mr. Florenhoff any money because that stipulation is going, based on our decision, is not going to hold up. So they're fighting your battle for you. You're just in your proceeding. I mean, you're sort of just hanging there watching what happens, right?
I don't know if they're necessarily fighting my battle, Your Honor, but they're...
Maybe a poor choice of words, but...
I understand your point, though.
The big interest is SGC has the money. They're the ones who Mr. Florenhoff says, you got to give me some of my, you got to give me the fee
Yes, that's a
out.
dispute between the former PI counsel and the
Right,
current PI
right.
counsel of the Campese firm. Correct.
So what's your dispute?
So our dispute will be stepping into the shoes of the plaintiff in the context of this malpractice action once the fee dispute is adjudicated and the stay is lifted here. I respectfully submit, and I'll be brief, that Justice Kennedy got it right with respect to staying the malpractice action to avoid inconsistent decisions. It's very clear by this court's order from June that there needs to be a determination as to the alleged misconduct in order to determine whether or not the appellants were discharged for cause. There is no need.
But aren't they intertwined so that they could just be consolidated and handled together?
Well, the way I see it, Your Honor, the fee dispute is more of a single issue hearing, whereas the malpractice case is a plenary action where there's additional issues of damages, causation, but there is overlap, certainly, and that's the reason why Justice Kennedy providently granted the stay.
I have to agree with Justice Kapnick. What I'm hearing here, what I'm seeing a horrible scenario is who's going to race to the courthouse to get the collateral estoppel argument. Because, depending if the guardianship goes forward in that fee dispute between SGC and Mr. Florenhoff, and Mr. Florenhoff doesn't prevail, I can see in this legal malpractice that he's going to be collaterally estopped for making some arguments, and that's, I don't think, is proper. So, and then vice versa. On the other hand, if Mr. Florenhoff goes forward in this legal malpractice, we lift the stay, he may have collateral estoppel arguments against SGC in the guardianship. That's too many collateral estoppel doctrine being floated around. It's best, like Justice Kaplan said, you guys all get into the same room together and duke it out. You can't argue one's getting collateral estoppel over the other, because I could see that appeal coming up, saying, hey, those guys got the first crack at it. That's not fair in terms of collateral estoppel.
Well, look, if you're looking
All
back
right?
at...
That's what it seems like going on.
If you look back at the docket, Your Honor, the PI case was commenced...
Look at this docket. This docket is a mind-boggling.
Well, there's a lot of dockets.
I'm pretty familiar with it.
And being the guardianship case, it's sealed.
Your Honor,
It's sealed and it's considered disposed of 11 years ago.
Yeah, well, the PI case has been settled.
Yes.
The Peachtree case has been resolved after the appeal. Now we have the fee dispute that's being adjudicated. Your Honor, though, you raised a very good point without even probably knowing it, is that why is this taking...
How did we do it? I might know it. She knows.
That's why she's sitting in the middle.
That's why we're in the middle.
Sits in the middle for a reason.
You basically said, but why is this taking so long? Well, Your Honors issued the decision in June of 2020. Well, at least I believe two of you were on that panel.
Right, we
Justice
were.
Long and Justice Kapnick.
Yeah, we like to be here when this is all over too.
You might be. And excuse me. The point that you made tacitly was that why is this taking so long? And unfortunately, after that order is issued, what happened was the Campese firm brought a motion to lift Judge Kelly's stay of the fee dispute because it was pending just an adjudication in that appeal. That was after an application by appellants to delay any discovery because of alleged medical issues. Now the appellants have cross-moved for protective relief on the very issues that were adjudicated on the fee dispute appeal. This has been going on for years. Discovery should have taken place 2 years ago. If you look at the record, the notice to admit, I believe it's dated 2 years ago, and I can get that reference for you if you'd like. This is just delay after delay, and unfortunately, I think a consolidation could even further delay it. We're on the cusp of
Counsel, I'm sorry.
Yes.
What I'm trying to figure out here is what your client hoped to gain out of this, and bear with me for a moment. There was a settlement X number of years ago. Pursuant to the retainer agreement you had with successive counsel, they get a certain amount of money from that settlement based on a percentage. So from the percentage that went to successor counsel, you had the Smiley and Smiley firm and the Flomanhaft firm who was seeking a piece of that portion that your client graciously, willingly, and contractually gave to successor counsel. True? Yes or no?
The position is...
Just bear with me. But that's true. That's how it works. So now the question becomes somewhere in that process, there was a loan made. Your client believed that the AIP was not competent to enter into a contract for that loan. We have the decision now that says, yes, he was not competent to make that loan. There was a business decision to settle it. Now your client wants its $55,000 back. It's not getting a greater piece of the settlement. That was resolved. It wants its $55,000 back. The Flomanhaft firm wants a piece of the portion that successor counsel got from the settlement. And the question is an offset. If he's entitled to the same, and I'm making it up, $80,000 and change that Smiley and Smiley settled for, and said, I'm entitled to $80,000 as well because we both co-counseled to get to the promised land in that settlement, then is the $55,000 an offset that or not? So doesn't it make sense to put it all together and just deal with it?
Like I said, given my experience in dealing with this case, I have reservations and concerns. My concerns are based upon the delay in the gamesmanship that I've seen throughout the years in this case. Years of discovery motions and delays, motions for recusal of Justice Kennedy. It's been a protracted litigation. And in fact, the fee dispute is supposed to be a summary proceeding, as I understand it. And we're still...
I got a feeling, I got to tell you, if we don't, if these things don't get tried together or don't get taken care of together, you're going to have collateral estoppel arguments going left and right like
All right, we're going to, I think you've answered a lot of our questions and left others open.
Can I make one point in closing?
What, one fast point?
Just like I said earlier, Your Honors, I would submit respectfully that Justice Kennedy providently stayed the malpractice action in the interest of avoiding inconsistent decisions and for economy. The case law in this department and under the modern case law of Uptown Healthcare, of Duranin, and Belaposky does not require complete identity of parties and claims. It simply requires that there be an overlap of issues and common questions of law and fact. It is very clear that there's overlap here because the issue of the alleged misconduct and
We
malfeasance...
got it. I think it's obvious we've got it.
Okay.
Okay, thank you very
Thank you,
much. No. No, we have the record, we will review it. Just tell me the page number, that's it, don't say anything else. Thank you very much. Have a good afternoon. Next and last case, White versus City of New York. Are you the co-defendant? Is that where they put you? Oh, okay. Okay, that's all right. I just want to know who you were. Fine. Mr. Isaac, nice to see you again. You have 5 minutes.
Nice to see everybody, Your Honor. My name is Brian Isaac. I represent the plaintiff appellant, as you know. Let me tell you what I'm not going to argue first, and then I can tell you what I am going to argue. Certainly, I'm aware of the Court of Appeals precedent, Gibbs against St. Barnabas, Kyle against Pfeffer. I'm aware of your precedent, Henderson-Jones and Elias against the city, and the Second Department precedent in Arpino, saying that time limits, CPLR requirements, discovery requests should be complied with. This is not a textbook view of what should be done, and I'm not trying to excuse it. But my argument is that the penalty of a striking of the answer under your decisional law is not appropriate for the simple reason that I think if you look at this record and you look at the trial judge's orders, and the trial judge's orders were correct. She gave 2 prior warnings. When that lawyer walked in on June 6th, I can tell you for a fact that he was not looking to get that judge upset. Now, were the authorizations...
He certainly didn't succeed in that.
He certainly did not. It's the understatement of the year. But if you look at what he did, was he obstructing discovery? He wasn't obstructing discovery. He didn't want to try to get some kind of improper advantage. He wasn't trying to do something in the sense of not complying with the court's order. What he was doing was, I think he was concerned about HIPAA, because lawyers should be...
That's been going on for months and months and months.
Judge, it had, and it shouldn't have been done. When a judge gives you not one, but 2 chances, and does it in writing, it's 90 and 105. 90, it's on the bottom. If plaintiff fails to respond to the notice to produce and provide authorizations as ordered, the plaintiff may be precluded. And then you go to 105, which is the June 4 order that you know about. Plaintiff must come to the next conference with the following: as plaintiff has failed to obey several court orders, etc. So yes, it's true, and they got the warning. But the thing is that this is a dismissal. And if you look at your decisional law, even where there are bad excuses, where there are belated attempts to comply, where the word you used in one of the cases was less than punctilious, which I thought was a great word, the striking of the complaint isn't appropriate unless there's willful and contumacious conduct. And the case I would like you to look at is a case called Viruet, V-I-R-U-E-T against Mount Sinai Medical Center. It's 143 Appellate Division 3rd, 558. I was careful to make sure it involved a reversal as opposed to an affirmance, because that's what we're dealing with, and I concede that the trial court has discretion to issue appropriate sanctions under CPLR 3126. This case looks to me like an analogous case, except that Viruet was better for the defendant, stronger for the defendant in this case. In that case, and I'm reading from your decision, you said, quote, Supreme Court's 5th, not 3, 5th and final order of discovery was made, and the plaintiff, quote, still did not supplement the bill of particulars to articulate the basis for her malpractice claims or demand for special damages, even though 5 years had passed since the commencement of the action. She also failed to provide completed HIPAA authorization forms. That's very similar to what we have here. So I'm not suggesting to you that you excuse it. To the contrary, I think the proper remedy here is to reverse the dismissal, but to issue a monetary sanction payable to the plaintiff, which you've done in 7 or 8 of the cases that we cited.
Mr. Isaac, I want to ask you another question. There was an allegation by the defendants that the plaintiff's attorney, which I know you were not the trial attorney or in the trial court, that the plaintiff's attorney put the wrong affirmation in support of his motion into the record, and it's not the papers that were submitted to the trial court judge. That's very disturbing to me. I didn't see any reply brief.
We did reply to it, and I apologize for that. They were right. If you look at our reply brief point 1, we can see that they were correct. I think what happened was that when, and I'm not great at this, Judge Kapnick, so I'm just giving you what I think happened. I think what happened is when the affirmation was put in, it wasn't scanned properly. That's what I think happened. But the same affidavit was put in on the related motion. I think it's pages 182 to 193. I don't think there was anything nefarious about it. I think it was a scanning problem. Sometimes it happens, it shouldn't, but that's what happened here. But the record itself, if you look at the judge's order before the judgment, they combine both. The affirmations say basically exactly the same thing. And there's just one argument here. The argument is that the dismissal of the case, despite the failures of the plaintiff's attorney, was just too severe a matter. So that doesn't go to those pages. I don't think there's any question.
How old was the case, counsel?
I'm sorry?
How old was the case?
The delay that my adversaries are...
How old, when was it filed?
It was filed, can you give me 1 second, Judge? It was filed 9/26/16.
So it's an old case.
Right.
And any plaintiff knows, first thing you do in a case is HIPAA authorizations. And you're telling me that not one, but two orders from the judge saying, show up the next time with the authorization, and the second time, not the first, but the second, no authorizations.
Oh, no,
But the
Judge,
judge doesn't have the discretion to say enough is enough?
I apologize. If that's what if I said that, I misspoke. It's not that he showed up with no authorizations.
He did, and she gave him another hour or two, right?
Right.
He did show up with nothing, and then she
Well-
said, come back, and he came back, and he
Wait.
still got it wrong.
Judge,
right?
I'm sorry. I just want to be sure. He did come with authorizations. They weren't the authorizations that the defendants claimed he should have had because they weren't restricted. It's not like he didn't come up with anything or just ignored the court's order. So he did submit the authorizations. They're on pages, I think it's 106 to 115, and then the second corrected authorizations, which I believe were filed some hours afterward, are on 117 to 133. I certainly agree with you that if the lawyer came to court with nothing, I wouldn't be here, because that's not tenable.
He did come to court with nothing, right? After he had been told.
Or did he come with, I don't know exactly what restricted authorizations are.
Yeah,
Apparently, the authorizations he brought were not what the defendants were looking for. What's a restricted authorization?
Well, I'm sorry, my time's up. Is it okay if I answer the question?
Well, I asked it, so yeah.
Okay, yeah, I'm sorry.
That's okay, it's okay.
So what they're objecting to, and I'll give you the pages, on 108, there's no social security number on the HIPAA authorization, and although there's a check mark for entire medical records, there aren't cross-offs for alcohol, drug abuse, mental health information, and HIV-related information. With respect to the Aaron's authorization on page 109, the conversation was restricted to the injuries in the case, and I'm quoting, lumbar spine, cervical spine, bilateral shoulders, right knee, thoracic spine. And then if you go to 110 of the record, that's the combined SSI, SSD authorizations. And I think the objection is that two of the boxes weren't checked, one for verification of Social Security number, and the other was the current monthly Social Security benefit amount. But if you look at the check marks that were made from 3 to 7, that's on 110, it actually includes the SSD payments and, quote, complete medical records from my claim folder. So yes, it wasn't what the trial court wanted,
but it
wasn't nothing.
Okay, thank you, Mr. Isaac. I know you're usually good at time. Now, the other two defendants, I do not want you to repeat yourselves. There's not, so are you the city? All right, I'll let you each ask for 5. I can't imagine you could both have 5 minutes worth of stuff to say. But go right ahead.
Good afternoon, Your Honors. Michael Bayron, representing the...
I'm sorry, I just have to say, how many times has the city not complied with the judge's request? Over 6 or 8 years. This is a couple years. But I guess the judge got annoyed at this plaintiff, so with that in mind, you're too young to know this, but I've been around longer than you.
Well, to that point, Your Honor, in this case, the plaintiff essentially pushed the trial judge to the point of exasperation. Okay, it's documented in both court orders. Justice Bluth said enough is enough twice. I think that demonstrates that the judge, as Your Honor pointed to earlier, this case was commenced in September of 2016. It stems from an accident that occurred in August of 2015. Okay, almost 3 years of litigation, and without the plaintiff being deposed, we are still at this issue of trying to receive HIPAA-compliant, unrestricted authorizations and Aaron's-compliant, unrestricted authorizations, which we're entitled to. And there were multiple conferences, as the record shows, and despite these conferences, despite being explicitly told in the June 4th, 2019 order what he had to come to court with at 2:15, not after the case was dismissed, and the subsequent e-filing of the corrected authorizations, the last-ditch effort to basically fix and correct the wrong, he had to come at 2:15 with the authorizations in proper form. He didn't do that.
That's what I understood, right? He didn't come, he had 2 orders, and on the second time, he still didn't come, correct?
Correct. He came
It's
to
only
court.
after the action was dismissed.
It was actually after the June 6, 2019 dismissal order was uploaded and e-filed the order with notice of entry was e-filed by the co-defendant, Project Renewal. Approximately 3.5 hours after that, that's when we get the corrected authorizations that were e-filed and, according to the affirmation of service, mailed out. But the fact remains, if you look at it's the time, the time speaks volumes. Like I said before, this stems from an accident in August of 2015. And like I said before, the plaintiff pushed Justice Bluth to the point of exasperation, where she said enough is enough in her dismissal order, and she repeated herself in the September 13, 2009 order regarding the plaintiff's motions to restore and the motion to vacate or re-argue. And regarding whether or not the trial court has the authority to issue a dismissal order, it most certainly does, okay? The plaintiff was warned on multiple occasions prior to the issuance of the dismissal order. The trial court has the discretion in controlling its calendars, and it was not an abuse of discretion here, okay?
Okay, I don't think we have any further questions, do we? Okay, so anything else you need
No.
to say?
Thank you, Your Honor.
Okay, thank you. I'll give you 2 minutes. Do you have anything to say that he didn't say? Please don't, I assume you agree with him? Yes, Your Honor. All right, only if you have something, I'll give you a couple of minutes if you have something different to say, but don't.
Yeah, I promise I won't repeat anything
Thank you.
my colleague has stated.
Go ahead.
Daniel Lay for Respondent Project Renewal. I just want to start off with restricted authorizations, why this is so important in this case. It's not apparent from the record because this is a slip and fall case, but the Project Renewal facility is a homeless shelter, and plaintiff was a resident there. So he's alleging that he slipped and fell, and the main contention in this lawsuit is about the injuries that plaintiff suffered.
About the what?
The injuries that plaintiff suffered. It's less about the fact that he, in fact, slipped and fell. It's just the fact that are his injuries as significant as he claims? Are they degenerative? And that's why these authorizations were so important, and why this litigation was, why this was such a focus of the litigation. Additionally, I also wanted to address the point about the affirmation that was not included. Actually, in our motion papers in the trial court below, we actually pointed out that the first motion made by plaintiff did not include any legal arguments, was not signed. It could have been not nefarious that it wasn't included when he filed it, but notably, the trial court gave plaintiff another chance. This is the pattern of willful and commutacious behavior that we're seeing from plaintiff. The plaintiff filed another motion trying to fix the mistakes of his initial motion. And lastly, I just want to address the point about penalty here. Plaintiff submits that the appropriate penalty is monetary sanction. We submit that the trial courts properly exercise its discretion in dismissing a case, and at a minimum, initially that's what we submit, but at a minimum, the trial court also suggested that preclusion of medical evidence in this case is appropriate as well. So we'll also put that into consideration. Thank you. Thank you, Your
Can't have a
Honors.
personal injury case without a medical evidence.
Exactly, Your Honor.
So I don't get
Either ways, I believe,
Same thing.
Thank you, Your
Okay.
Honors.
Your Honors, I'm going to truncate my argument because I know that this isn't the most complicated case, and I know you know how to do it. But Justice Scarpula, if I can, I've omitted to mention one thing about the Viruet case that related to your question to me. The delay in that case on paragraph 2 of the decision was 5 years, not as long as this. And in that case, there was never a cure. In other words, according to the court's decision, as I read it, There was a failure to comply with the discovery, and there wasn't even an attempt to cure that.
Well, a cure after the action is dismissed is really not a cure, right?
Well, that's
Not a
true.
cure at
That's
all.
that's
After you know the action is dismissed, you can't really cure.
right. That's 100% true. But when you read the record, and I know you have, what the plaintiff did is said, look, if I made a mistake, because obviously he knew the judge, and I'm not saying anything bad about Judge Blitz. She's a terrific judge. She was obviously upset at this. You read her decision, it's pretty clear she was upset about this. He said, I'll run back and I'll get the authorizations in a minute. She said, no, too little, too late. And then he upfiled it. I'm not saying the upfiling changes it. All I'm saying is that on this record, I don't think you can say factually, and I don't think you can say legally, that the plaintiff's lawyer, when he went to the court on June 6th, was trying to antagonize a judge, especially a judge who gave him not one, but two chances. And I just don't think that the monstrous penalty of a dismissal is appropriate here, where you can give credence to the decisional law by imposing a fine and not the ultimate remedy of dismissal. It's my argument. Thanks, I have nothing else.
Okay, thank you, counsel, very much. I don't know how to stop this. How do you stop this? Okay. Check this and make sure I did this right. Okay.
Guys, take care.